income tax matter of the Law Department. We had filed a petition before your lordships previously, which was dismissed as withdrawn on account of the fact that we had invoked Section 260A of the Income Tax Act, besides Article 226. We're approaching your lordships solely on under Article 226 at present. We're challenging the jurisdiction initially, and also there's a question of natural justice because they did not consider a reply in their order.
Have you served notice to the Standing Council?
The Standing Council is not taking notice, Lordship. We have served upon the department itself.
Do you have any factum to show factum service? Any in the notice? Yes,
Lordship, I don't have it in my copy.
Yes, heard Mr. ESD, the Red Council for the petitioner. Issue notice. However, it is noted that the Deputy Commissioner Income Tax TDS has received the petition on 19 March 2026, but however, there is no representation today. A list after 1 week.
Grateful, Lordship.
For the orders and to await appearance of the sole respondent. To await appearance.
Grateful, Lordship.
Lady list item number 1.
Please, Your Lordship. Your Lordship will be filing the counter affidavit and cause the delay, Your Lordship.
Where's the officer? He said expected next day the affidavit should be on board. In which concerned officer shall present personally. Where's the officer?
Lordship will be filing the cause of the Lordship.
Yes, you received notice. Then?
Lordship is still getting vetted by the Learned Advocate General. Will be filing the cause of the Lordship.
Otherwise, this is a judicial order.
Lordship, the cause of will be filing it, Lordship.
Take it after some time. Yes. Call out before the end of the vote. We hope you file it by then.
Item number 2.
Yes, Mr.
My Lord, we have deposited 8 lakhs as per the direction of the Lordship. But portal is opening, but the demand of 25 lakhs 1970 is arriving. Unless until that is will state, you are not unable to open the file, that is creating disturbance. Till then, that is the same situation is there. So further purpose, I have filed an IA also.
You file a?
IA, I have filed.
Where is it? This case is here?
Yes.
Initiated by CGST in the official portal. Supporter in Mozilla to obtain instructions. Or you want to file objection?
No, my Lord. In fact, I spoke to the department. They are saying because it's all centralized, it's online, my Lord. They are trying to contact the controlling, whoever is controlling.
You get instructions 1 week.
Yes, my Lord. Obliged.
Item number 3.
With the district. Here we are required to file affidavit, my Lord. I'm praying for some more. But there are 2 more matters, my dear, connected matters. Those are coming on 9th of April. If it comes together, we'll file affidavit on all the matters.
Lordship, interim and continue in this.
Yes, Dr. Mozika pays for the 2 weeks time to file affidavit. The same objected to by the Council for the petitioner. Affidavit is allowed interim order to continue. Stop. This further submitted there are 2 other
WPC 467 and 468.
pending for this court.
467 and 468 of 25.
Namely WPC number
467 of 25.
467 of
25 and 468 of 25.
He prays that same as the matters come on 9th. He prays that the instant matter be tagged along. Yes. Prayer is also allowed. Yes, just on 9th April.
9th April.
Yeah.
Item number 4.
Department, Lordship.
Okay.
I require 4 weeks time to file my affidavit in opposition, Lordship.
Here, Mr. Kaushik Jain, are you standing counsel? Are you standing counsel for income tax? Mr. Jain,
Lordship, the voice is not audible, Lordship.
Why is not audible? Who's there?
As far as I know, Lordship, he is the junior of Coil.
I'm the junior of Mr.
One
SCK,
second.
Lordship.
Yes. Are we audible now?
Yes, Lordship.
Yes. Are you the standing counsel or junior standing
No,
counsel?
Lordship. I am junior to the standing counsel, Mr. SCK, Lordship.
How much time?
4 weeks time, Lordship.
4 weeks time. Yeah, Mr.
K. Jain, Lordship. Yes,
In the
Lordship.
Koshik invites Dr. Avas, Mr. S.C. Kayal. Please find out for the 4 weeks time to file affidavit. Yes.
Affidavit in opposition.
Yes.
Much obliged, Lordship.
Please, S.C. Kayal.
Item number 5.
Lordship, in this matter, I am also applying for the income tax department. I require 4 weeks time to file my affidavit in opposition.
Lordship, I am from the petitioner side. There is an interim order that may be continued.
Yes. As paid for the 2 weeks time of affidavit, the interim order finish shall continue till the next date.
Obliged, Lordship.
Much obliged, Lordship.
Second call, item number 1.
Yes. Where's the officer?
My lord, we've had some slight problems, my lord. If kindly your lordship could just adjust us for just one more week, my lord.
Yes, in item number 1.
Lordship.
Then where's the officer? You call him now.
My lord,
The judicial order, see, we can't, there's no question of.
my lord, just a matter of one more day then, my lord. We'll have it on board by tomorrow, lordship.
File it by today.
My lord, it's a bit
If you
difficult,
file it by
lord.
today, then you
Lordship,
will-
kindly, my lord, by tomorrow at first hour, my lord. We'll file it by tomorrow morning, first hour.
Yes, you should appear personally. We can give you time, but I think why
No,
you
no,
not
that'll
appear
be a bit-
personally?
a
Why
bit-
not appear personally to air grievances or your difficulties?
My lord, the
That's what
personality,
comes
the difficulty is from our side, lordship.
So
Kindly, my lord.
Who's the officer?
Commissioner.
Who's he?
The DC, lordship.
No, thanks. No, fine.
It's tax department, lordship.
Yeah.
My lord, we'll have it on board by tomorrow, lordship.
The thing
My
is that we can't-
apologies,
we have to
lordship.
appear. You might file your affidavit.
No, my lord, my
tomorrow,
apologies,
but
lordship.
You should be here in person to ask for time or put an application.
No, my lord,
It's a judicial
I'm
order.
making the prayer on behalf, my lord. Kindly, my lord, just by
Who's
tomorrow,
this is spot number 1.
tomorrow morning, my lord, we'll have it on board, lordship.
Have it today, otherwise we'll convene a special bench tomorrow.
Lordship,
Yes.
we'll have it by the end of the day, lordship.
Yes, though by order dated 19/2/2026, this court had directed that the affidavit be on board by today, failing which the concerned officer be present personally. Today, however, MSNG Miscellaneous Senior Government Advocate has made a prayer that due to certain difficulties, the affidavit could not be filed as yet, but undertakes to file the same in the course of the day.
Reply, lordship.
Yes. Yes.
Any mention?
My lord, I have a small request. Along with item number 2, 3 and 4 of the supplementary list today, my lord, there were 3 other matters, my lord, which has not come on list. They are already numbered, my lord. Can
Similar?
they be also similar, my lord? Can they be, my lord, call, my lord? Oblige, my lord. Oblige.
Please, Lordship. Lordship, I beg to mention this hearing item number 33 and 35, my lord.
Who's for the other side? You're the other side.
33 is GHDC and the preference.
No objection, Your Lordship.
Can't hear you.
No objection, Your Lordship.
Any appearing for respondent number?
529, Your Lordship.
Number?
529.
What's the matter about?
This is regarding the Nokmasip matter, Akung Hetman.
529. Yes.
And for respondent 124, Your Lordship.
Yes, and?
Then similar prayer for number 35, my lord, item number 35.
It's been heard in part.
No, Your Lordship.
Last
No, Your
time it
Lordship.
come, but the other party have taken time.
Who's the paying for the respondent?
I am, Your Lordship, respondent number 4.
Oh, you.
Respondent number 3, Your Lordship.
No objection.
Your Lordship, I pray that last opportunity may be given to them, Your Lordship. And I pray that hearing may be positively taken on the next
Take
day.
it up today. You're ready.
No problem.
No problem. Okay. Then no adjournment. Yes.
Lordship. Much blessed, Lordship.
Honestly, adjourning, there's no need to adjourn honestly.
See, item number 37, Lordship. I was, as per the last order, I was required to obtain some instruction, Lordship. So I pray for 2 weeks' time, Lordship.
What's the matter about Mr. Latsangluya?
Lordship, appointment, Lordship. Termination of my service.
My Lord, this is a case where he was
Engaged in master role, Your Lordship.
he has been disengaged.
Okay. You're terminated.
Yes,
Not-
Lordship. Disengaged.
2 weeks.
Lordship.
May I please, Your Lordship, I beg to mention item number 28, my Lord.
20?
28.
28.
I'm praying for 2 weeks' time, Your Lordship.
28 is Klingshan Lingkhoi.
Yes, sir. For respondent number 1 to 3. Lordship.
And you're for?
Number 5.
On behalf
And you're for?
of PS
Record the
Nohali.
names, no? Yes.
On behalf
2
of
weeks,
PS
yes.
Nohali.
Yes.
Pleasure.
Much obliged, Your Lordship.
So I beg to make a mention for item 32, Lordship. Item 32, Lordship. Miss Ma'am S. Bhattatarji, she is still on leave, Lordship, till. Then Ms. S. Tapa also is on leave, Lordship. So I'm praying that.
Okay, 2 weeks, yes.
May it please Your Lordship, I beg to mention item number 27. Your Lordship, if this matter can be taken up after 2 weeks.
27 is. You're for Mr. Jindal?
Yes, Your Lordship.
No objection, Your Lordship.
Yes. Yes.
Much obliged, Your Lordship.
Record करते हैं हम.
But Lordship, I beg to mention item number 29.
20?
29. I pray this matter may come after 2 weeks.
Are you been informed?
Yes.
Lordship.
Yeah, objections?
Objections, Lordship.
Yes.
Much obliged,
Hello.
Lordship.
Supplementary list item number 1.
Lord, this pertains to selection of post of my lord veterinary field assistant. Lord, you could look at the advertisement. The advertisement, my lord, specifies at page 16. Page 16, my lord. 16. Towards the bottom, my lord. The educational qualification, my lord, is diploma certificate in veterinary science from a recognized university. That's serial P, my lord.
A.
In the second column, page 16.
Page 16, second column, MOP.
P.
Trade VFA.
VFA, veterinary field assistant, diploma certificate in veterinary science from recognized university, my lord. Originally, my lord,
10 plus 2 pass 2 year diploma with 2 year diploma certificate in veterinary science with from recognized university.
My lord, he had appeared. In fact, 3 candidates were selected. There were 3 posts only. He was shortlisted. Finally, my lord, he was omitted from the select list because his educational certificate, my lord, is saying that his course is veterinary pharmacist training.
Yes. Yes.
Now the question of, my lord, whether these 2 degrees are equivalent was there or not had come up.
Is it a 2-year course, this one?
Yes, my lord.
Diploma veterinary pharmacist training course?
Yes, 2 years, my lord. Lordship would come at page 14. Annex 1.
But veterinary field assistant different from pharmacist?
No, the question is basically equivalence of, my lord, qualification. So to that extent, the university, my lord, had clarified at page 23.
Yes.
Now, when I submitted this certificate, my lord, of equivalence, no further action has been taken, my lord. The post still remains vacant, my lord.
Yes, Dr. Mozika.
My lord, prima facie, my lord, veterinary pharmacist and veterinary science. But I'll have instruction file after.
Yes, I heard Mr. B. Patak, then council. You should notice Dr. Mozika with MS Sunsu present. No further notice required. The grievance of the petitioner is that though on being selected, provisionally selected,
my lord,
selected to the post of veterinary field assistant, the appointment has not been given on the ground that he is holding a diploma in veterinary pharmacist.
My lord.
Veterinary pharmacist. Stop. Mr. B. Pathak, Learned Council submits that the diploma of the writ petitioner is equivalent to the 2-year diploma course in veterinary science, which has also been confirmed by the institute from where he obtained the diploma.
My lord. Thereafter, I submitted this and no action has been taken, my lord.
He further submits and diploma. He further submits that though this certificate has been given to the respondents, no response has been forthcoming. Any other prayer?
No, my lord. If this is considered actually my Annex 7 representation, my lord,
yes,
because they have to, of course, cross-verify it with the university.
Yes. In this view of circumstances, this is a matter after 2 weeks for specific instructions by the respondents.
My lord, that post, my lord,
yes,
though it is unfilled as of now, 3 were selected.
It's unfilled.
It is unfilled, my lord.
I'll have instructions whether filled up or not.
The said post is yet to be filled up. The same shall not be acted upon by the respondents. It's further provided that if the said post is not filled up, it shall not be acted upon or filled up by the respondents till the next date.
Item number 2.
Well, 2 again arises out of the same advertisement, but then the issue, my lord, here is reservation.
From rifles.
My lord?
You got a monopoly now, not from rifles.
No, my lord. Mr. Chanda also, he has also part monopoly.
Yes.
My lord, this is relating to reservation, my lord. Lordship knows that economically weaker section EWS is a vertical reservation.
Right.
So what they have done, my lord, is that they have, my lord, not followed the vertical principle. So as a result, my lord, what has happened, the unreserved, my lord, category, the highest mark is 63. And in the EWS category, the highest mark is 74. That 74 ought to have, my lord, qualified as to the general merit list, my lord. As a result, my lord, this petitioner, who is having 59 marks, he is not selected, even though in the unreserved category, somebody with 52 marks is selected.
I heard Mr. Simpson issue notice. Dr. Mosca, same order with for the position with Sunsa's present, no further notice required. Just after 2 weeks, yes, for instructions have to be.
My lord, same, my lord, if that one vacancy, my lord, should be, my lord, kept, my lord. Appointments have not been. My lord, prima facie wrong, my lord. The whole reservation system has gone wrong, my lord.
3.
3 is slightly different, my lord. It's because in the scheduled caste category, though he had qualified, my lord, and medical was also done. Obviously, therefore, he had cleared, my lord.
One second. He's scheduled caste category.
Scheduled caste category.
EWS.
Not EWS. Others are all EWS.
Same recruitment,
my lord. Same recruitment, my lord.
Yes.
But in scheduled caste, my lord, nobody was selected.
What's this post?
Upholsterer, my lord. Nobody in scheduled caste is selected, my lord.
How many seats are there for scheduled caste?
My lord would come to the advertisement, my lord. Upholsterer, my lord, scheduled caste 1 post was there. Page 17, my lord. Sorry, 13. Page 13. 1 post in scheduled caste, my lord.
But you're fit, otherwise medical?
Otherwise fit, my lord. Medical fitness also is there, my lord, at page 17. Initially, he was, my lord, suspected of hypertension. Then in the review medical, he was cleared to be fit, my lord.
Anyway, you should notice the same.
And that one, my lord, unfilled post
here also?
My lord. Unfilled, my lord.
If any post remains unfilled, 1 post should be kept for. If at any post, if the 1 post, if the reserve post, that is SC, is unfilled, no action should be taken by the respondent to fill the same till the next day.
4 is, my lord, again EWS, and 3 items I had mentioned are also EWS. All general category, my lord.
How many seats? How many posts are for EWS?
EWS, my lord, the post are, my lord,
pharmacist.
Lord, you would look at the advertisement again. EWS, my lord, in this case, it is pharmacist.
1 post.
One
post.
Then how many people are filed petitions?
My lord, they are all for different posts, my lord.
Different
pharmacist only 1. The posts are different, my lord.
So your provision selected here also?
My lord. But then because of this wrong application of the vertical reservation, my lord, they have been left out.
5.
5 is, my lord, pertaining to promotion, my lord. Here, my lord, the petitioner was all along senior. However, while not pursuant to an order passed by this court at Annex 4, page 17, the review DPC was done. And the review DPC had, my lord, promoted this particular private respondent retrospectively from the same date that I was promoted, my lord. Now the question is, my lord, the seniority. My case is that, my lord, since somebody who had been retrospectively promoted and that promotion is only notional, yes.
The petitioner here, how do you say?
My lord?
Who's the...
Respondent number 4, my lord.
Respondent number 4 was the earlier petitioner, my lord. He had challenged that his promotion was not considered, my lord, because his ACRs, etc. were not, my lord, properly counted. So, upon direction of this court, my lord, a review DPC was done.
One of 7 in the earlier case.
My lord, I was there. I have no grievance as far as promotion is concerned. My grievance here is the seniority. Now he has been retrospectively promoted, but then I have worked on that particular post already for 3 years, my lord.
Counsel for issue notice, same order.
No interim.
No interim, 3 weeks for it.
My lord, the next promotion is due on, I think, 30th of June. Before that, if the instructions come, my lord, we can settle. 30th June is the next promotion due, my lord. Because otherwise, he will get promoted being senior to me, my lord. Obliged, my lord. Deeply obliged.
Where's the Excise Act?
Lordship.
How many meters?
200 meters, Your Lordship. 150.
You have that, yes.
May I place it, Lordship?
Yes.
It's your case, by command. Lordship, kindly see 180, 183. 2, Your Lordship. Then Lordship, amendment came in 2015. Lordship, kindly turn to the next page, Your Lordship, at page 26. This is amendment of Rule 183, Your Lordship. Kindly see 2A, Your Lordship. No IMFL and beer retail off and on licenses shall be established within distance of 200 meters from any place of public worship or educational institution or hospital. Then Lordship, kindly have the amendment of 2018, Your Lordship. Lordship, kindly turn to page 378, Your Lordship.
Yeah.
Lordship, that is also again amendment of Rule 183, Your Lordship. This is with regard to explanation, Your Lordship. For Rule 2A, the existing IMFL shop would not be affected in case this shop were opened before any establishment of public worship or...
It doesn't come to him because he's 200 meters away.
Lordship, yes. Only thing is that, Your Lordship, as per the minutes of the report of the Deputy Commissioner, Your Lordship, certain objection, Your Lordship, have been raised by those people.
Let them be impeded.
Let them come, Your Lordship, and let them have a say.
They will say that, yes,
Lordship.
That they should be able to understand the law also. And objection is not be just for the sake of objection. No, moral values are not is not a legal consideration. It's like whatever your beliefs or morality. And because the only consideration is that everything is in order, and if illegal wine stores, they'll stop bootlegging that area. So that is a complaint.
Lordship, kindly have again that minutes of the proceeding, Your Lordship.
Yes, I mean, not necessarily, Mr.
Lordship.
Have you filed an affidavit? The minutes?
Yeah, not
no, Your Lordship. I just placed it before Your Lordship
yesterday.
yesterday.
Put by affidavit. Yes, sir.
Lordship, yes.
Yesterday, Ms. Andy Shulai today has apprised the court that as per the Meghalaya Excise Act, the distance of as per Rule 183 2A, no IMFL and beer retail off and on license shall be established in any area with a distance of 200 meters from any place of public worship or educational institution or hospital. In the instant case, it is noted that in the minutes of the meeting held on 19 March 2026, it had been categorically recorded that the shop is approximately 200 meters away from Tura Town Church and Nexim Gittam Church, and the nearest education institution is at least 100 meters away from the nearest development committee. That is the Walbagre Development Committee, whose members were present in the meeting. It appears, therefore, that the petitioner, apart from possessing a valid license to operate operate the wine shop, also comes within the exemptions provided under the Meghalaya Excise Act. But however, as objections in the meeting had been raised by the
345, Your Lordship, in the
we will do by name, by
Lordship, this is
Nixing Baptist.
Nixing Jitim Baptist Church.
By the persons who have been noted at page 3 of
Lordship,
the report,
yes.
At serial number
3, Your Lordship. 345, Your Lordship.
Yes. Before the matter is disposed of, the petitioner is directed to put in an appropriate application for impleading the said respondents.
Lordship.
Yes. Just after
2 weeks.
After 2 weeks, Mr. Andy Shulai also prayed to bring the minutes of the meeting. on record by your affidavit.
Lordship will do it.
Lordship, may pray that I may be just for
How
timing.
to run the wine
Yes.
now?
Lordship,
I will undertake. If anything happen, I will immediately close it. I'll undertake it with regards to the law and order problem. As of now,
2 weeks, you've waited for so long.
because I'm suffering a lot of
one week
loss.
you put it, you file the application fast.
Okay, 1 week, Lordship.
1 week, yeah.
Within 1 week. Within 1 week, Lordship. Much blessed, Lordship.
Give them private notice and then we'll settle the matter.
Much blessed, Lordship.
Yes.
Please, Your Lordship.
What is this matter?
Lordship, this matter pertains to a decision by the lower appellate authority, Lordship. If I may just start with the brief facts of the matter, my Lord. Lordship, on being aggrieved by a decision of the Dorbar Shnong Lordship, the plaintiff, the petitioner herein, had approached
The appellant.
Lordship, the appellant, my Lord, had approached the trial court, Lordship, for declaration of suit, and also had applied for an interim injunction, to which the trial court was pleased to grant, Lordship. And aggrieved by the same, the respondent herein had filed a Miss Civil appeal before the lower appellate authorities, Lordship. My Lord, the point of determination before the lower appellate authority, Lordship, was whether the Dorbar Shnong had functioned as a village court or as a Dorbar Shnong, Lordship. If I may take your Lordship to the impugn order, Lordship, at page 100, Lordship, Annexure 13. The lower appellate court arrived at a decision, my Lord, which is at page 125, Lordship. If I may read, my Lord.
Yes.
On perusal of the order dated 9/10/2023, passed by the village court, the case was decided on the basis of the evidence and the documents submitted. It was observed that the plaintiff did not possess documents to confirm the ownership over the land called Laisari, but the real owner is the defendant so-and-so. The village court of Dorbar Shnong Maubri, presided over by the headman, had passed the order in its judicial capacity and exercised its power under Rule 11 of the United Khasi Jaintia Hills Autonomous District Administration of Justice Rules 1953. Therefore, if the respondent number 1, the appellant here in Lordship, was aggrieved with the order dated 9/10/2023, she could have preferred an appeal as provided under Rule 19 of the United Khasi Jaintia Hills Autonomous District Administration of Justice Rules 1953, that a subordinate district council court is a court to hear appeals from the village courts. As such, institution of a fresh TS is not maintainable, and the ad interim injunction order dated 15th of March 2024 cannot be effective. In light of the above, the impugn order dated 15/3/2024 passed in Miss Case number 22 of 2024 arising out of TS 13 of 2014.
So they recall the injunction order.
Lordship, they had actually set aside the entire.
No. What happened here is that there was a order of village court or whatever. Then
So-called
against that,
village
an appeal was filed by them.
No, Lordship.
By
The
you.
village court, there is no village court, my
Who
Lord.
filed appeal before the district council court?
They had filed.
Before the district council court, they had filed, Lordship.
appeal.
We filed the title suit, Lordship. We
Okay, you filed a title suit.
We filed a title suit, Lordship, because we are the owners in possession.
Okay, filed a title suit
Yes.
saying that it's not a village court. It's just a darbar ruling.
It's just a Dorbar Shnong, Lordship.
Then
Then the trial court was pleased to grant interim on 15th of
that was
March,
recalled by this order.
Lordship.
And the
And the
suit is
same,
dismissed.
exactly, Lordship, dismissed. So because it's not maintainable. So my Lord, we have approached this Honorable Court, Lordship, because for the reasoning given by the lower appellate authority stating that the village Dorbar had functioned as a village court, Lordship. My Lord, the lower court records have been called for, Lordship, and the order has been flagged, Lordship, at page 109.
Then where's the appeal? The order and appeal? It's not appeal. Where's the suit? The order and the suit which you had filed?
Lordship, it's here. Order of the suit, my Lord, is at page 35, Lordship.
Yes.
So this is the ad interim injunction, my lord.
Or they set aside the part of the trial court.
Reasoning that the entire title suit is not maintainable, lordship. So, my lord, we have come by way of an appeal, lordship, for which reason that this honourable court was pleased to call for lower court records, lordship.
Yes, what is the submission?
My lord, if I may just complete just one more line,
Yes.
my lord.
The only thing is that the only question is whether it was a village court or not.
My lord, we already have we had already sought information from the district council at page 132, lordship, of my appeal.
There are only 2 village courts operating.
It is not a village court, lordship. This particular village darbar has not been constituted as a village court as per the act, lordship. So the decision by the lower appellate authority is void, lordship.
So the thing is that we'll remand it back then.
Your Lordship,
court.
yes, we agree to that. Your Lordship, it be remanded back.
We'll pass
But let the order be portion set aside. Lordship, status quo we maintain, lordship, but set aside at portion.
There's some urgency if that directions from this court for injunction to be heard at the earliest, Your Lordship.
Yes.
Item number 2.
Much obliged, lordship.
Yes. Have you tried application?
We have filed the affidavit, bring on record the 2 letters dated 11 July 2025.
Who's the XO?
Lordship.
MS XO is whom?
XO is
for the petitioner?
Yes, Your Lordship.
Last time, finally replied application, file maintainability, where's the reply? It's been filed.
No, Your Lordship, will
See
actually...
the last order? Who is telling maintainability? Mr. Karuna. Have you filed a reply to the objection?
No, Your Lordship, I will not be filing any reply. Will be ready for the hearing, Your Lordship. I think there was some miscommunication.
The matter, my lord.
It's only a small issue. Just there also on maintainability.
At the outset, Mr. Prasad submits that they will not be filing any reply to the application on maintainability of the instant writ petition. Where's the application? It's a miscase. Where's the application?
They file an affidavit challenging the maintainability.
5th August 2025, my lord.
5th
August
2025. 2025, my lord.
August.
Yes, my lord.
Yes. Yes. Why do you say you won't come within the ambit of 64 and 77, Mr. Prasad?
Yes, yes, my lord.
Yes.
Lordship, may I have first my writ petition?
Yes.
I do agree with the learned AG that 64 is there to decide the rightful compensation. Now, if you see my prayer, Lordship, in the writ petition,
prayer won't change the legal position.
my prayer is not to decide the title, Your Lordship. My prayer is twofold.
Where's the prayer page?
Page 21 it begins.
Yeah.
In the premises of a sir, is prayed that Your Lordship may be pleased to issue a rule calling upon respondent to show cause to why a writ in the nature of mandamus or any other appropriate writ, order or direction should not be issued, directing respondent 1 to 3, which is the state to take steps for recovery of the land compensation amounting for parcel ID so and so, wrongfully released to respondent number 1 and to take penal action against respondent number 5, and 6 for misleading and producing false document under section 84 of the Right to Fair Compensation in Land Acquisition, Rehabilitation and Resettlement Act, and on course being so and so and so, Your Lordship. So here, Your Lordship, I've come before Your Lordship. I agree that I have to avail section 64.
Yeah.
But my submission is, Your Lordship, if we may go through section 64 of the
Like the Act. 2013 Act. Land Acquisition. 2013. Yes.
Just read section 64, Your Lordship. Any person interested who has not accepted the award, Your Lordship, kindly note the wordings, who has not accepted the award, may by written application to the collector require the matter be referred by the collector for determination of authority, as the case may be, whether its objection be to the measurement of the land, the amount of compensation, the person to whom it is payable, the rights of rehabilitations under section chapter 5 and 6 of the apportionment of compensation, provided that the collector shall within a period 30 days from the receipt of the application make a reference to the appropriate authority, provided further that where collector fails to make such reference within the period so and so, and the case may be requesting the director to collect make also. The application state the ground which the objection to word is taken. A is person making was present represented before the collector. In other case, within 6 weeks receipt of notice under section 21, within 6 weeks from the date of the collector's word. Provided further, the collector may entertain application after the expiry of the said period within further period of 1 year if he is satisfied there is for sufficient cause for not filing it within the just specified in the first proviso. Now, Your Lordship, this entire provision has to be read not in isolation that I have a recourse to 64 when I have not to decide the title. Here it says, Your Lordship, when the main word here is a person who has not accepted the award, it means the compensation is still.
Okay, you see what are the facts of your case? He's saying that.
Now, I'm not here, Your Lordship, that everything was, I am the rightful owner.
You're rightful owner. That is your claim.
I've come here saying I'm rightful owner. I'm questioning the procedure in which the compensation was released.
Okay.
Now, under
in which manner was it not proper, or whether?
So, Your Lordship, the petitioner's here name had appeared in the preliminary notification under section 11.
Where is that?
Now, Your Lordship, may have annexure 30, page 32. Annexure A.
I'm sorry, my lord, I can't hear my learned friend.
32?
Now we have page 32C, Your Lordship.
C?
32C.
Yes.
Now we see the first three. Your Lordship.
Plan.
Yes. Crang 22.2, Crang 22.3, Crang 22.5. These are in the petitioner's name.
Who are you? You're the clan leader?
We are the clan, Your Lordship, representing the entire clan of Maulam.
Okay.
Now, what has happened after this? Although my name appeared under.
So you shown out here. The area is around 6,699. Okay, yeah. This is the only area that you're contesting. That is
yes, this
6,000 feet, 65.68 square meters, 699 against 700 square meters, and 3642. Right. So the area is small also. It was 60,000, 6,000 and 36,000 square feet.
Yes, Lord.
Yes.
Now here we're only concerned with
acres. Yes. Yes.
I'll just take Lordship.
How 59? This is okay. 59, 66.
Now we are only concerned with parcel ID number Crang 22.1, Your Lordship.
22.1 is not here. That's 59 is Crang 22.2.
Now before that, 32B, Your Lordship. May I have? That's serial number 56.
You're not bothered with 22.1, that's 58.
No, Your Lordship, we're only bothered with serial number 56.
No. Serial number 57, 56 is some Taina Maulong. 58 is your Maulong clan. 32B, right? Page?
Page 32B, serial number 56, the left, right hand side, Your Lordship. Right, there are two columns, one to the left, one to the right.
The same parcel?
There were initially 4 plots of land. Now out of this, we are only concerned with 22-1, which we have come before this court. But my name has been identified
twice. Even here, 58, the same land. You see, 1 second, 22-1, 58 on the left hand side. Molong Clan, Crown 1946. But how is it possible?
Only with serial number 56, Krang 22-1.
What about this Krang 22-1 at the right, the left hand side of the page at 58? What is this then? Okay. This is same village also.
Same village also.
Then
these are different plots.
No, see, different plots. 22-1 can't be a different plot. This is 22-1 only. Krang village, Krang Molong Clan private. This is so and so. And even 58 also Krang Nongrum. Same.
The parcel ID are different, Your Lordship.
No, parcel ID is
22-1, 22-2, 22-3.
Same, 22-1.
The area also are different, Your Lordship.
I don't understand, yes.
Because they are right hand side and left hand side as well, Your Lordship.
You sure you're agitating for the right piece of land then?
Yes, Your Lordship. Only concerned with 22. Yes, Your Lordship.
Otherwise, if we can't even discern from the materials here that whether it's the right piece of land or not, whether you're 22-1 left hand column or 22-1 right hand column, then how will you go forward?
Well, here the entire dispute with regards, there are two factions of the so-called Molong clan. I am also one of the elders, and the petitioners also they are claiming to be the elders. Also, if I've verified my affidavit, affidavit dated 21/7/2025.
Yes. Just check that, Mr. Prasad. You have to be clear. I mean, your fact before we proceed. Yes, page.
Well, can you see, just with regard to that, that aspect, this is left and right changes. On the left hand side is on the top is mentioned, left ROW, left channel.
Okay. So road going through.
That's why, Your Lordship.
Then doesn't mean one plot only. That means two plots. Then left hand side 22-1, right hand side 22-1.
As far as concerned with this case, Your Lordship, it's only the right hand side portion.
Then you say that.
We're not concerned with the left hand side. Left hand side is still under dispute, Your Lordship, pending before.
How would we dispute the road going through? Must be the same plot before. The left hand side compensation been released.
Some compensation has been released.
Left hand side, right hand side also released.
Some has been released, some has not been released. As far as 22-1, this also has been all been released, Your Lordship.
See, you bring up the disputed fact that this court and writ jurisdiction can't touch all those matters. They can't touch, but you can't come to any conclusive finding.
Lordship, I'll just prepare a small chart, Your Lordship, for better understanding of the right hand side.
Required to be led,
At least you'll be, I mean, with your facts, you'll be, make the court understand.
Yes, sir.
Or you'll just be swimming around.
Because I've mentioned in, we just have page 5 of my writ petition. We've made a table.
Prepare a small chart, exactly which is the plot which you are contesting,
yes,
and which you say who has gone to whom the compensation, that's all. And but otherwise, I don't think your writ petition will be maintainable.
Well, even otherwise, the remedy lies before the civil court.
We'll see that. I mean, that is next month. A list after 1 week for further orders. To allow our list after 1 week to allow the General Counsel President to prepare a chart depicting the correct plots
of land
which are in contest.
Yes, Lord.
With regard to compensation. Yes.
Item number 3.
Item 3, 4 and 5 all are related to work charge implied, the issue of retirement, age of retirement 58 and 65. Now, in the counter affidavit has been filed in item 4, my lord, Ballari, that is the lead matter, my lord. So the your lordship may hear Ballari Kitta, item 4, my lord.
But we are yet to file. We just received, my lord, few days back. We will file a rejoinder, my lord, it comes after a week, after 10 days.
My lord, because some of them have retired also, my lord.
See,
Will retire also.
we can do one thing. Those only serving above 60,
58, my lord.
you know, we are over 60 now, correct?
Yes.
You go to 65 then. Those who, for prospectively, you'll stop at 58.
Yes, that can be only interpretation of
That's
that.
only interpretation.
My lord, age of retirement is 58 as per our.
No, but then you can't make now. What are you going to do with the two additional years they served or 3 additional years? Now you say respectively they should retire at 58 when they're already 62 years old. Then
we have not reduced the age, my lord. Age is 58 only, my lord, and that is what.
No, but that your executive order is there that they'll continue.
Executive order and the scheme, my lord. It's
and how special are they that you know that at 65 they can still do pastoral work? Anyway,
no, because they can't.
They are RCW. They are RCW.
Sorry, Mr.
RCW, my lord.
Dr. M. Bozikala Senior Counsel prays for allowed 10 days time to file rejoinder to the affidavit filed by the state respondents.
In item 4, this will be
WC number 7 and 6.
But the interim order is there in all 3 matters. In all 3 matters.
We have it for fine.
All the 3 matters.
But that will be, this is the observation of court. Now you allowed them, they are, you know, it's not that they're serving illegally, you're allowed to serve. Only the petitioners only, the rest you can put them out.
This is a legal question which we have, my lord, before lordship. Kindly see that.
We'll see about that question has been, it's not a question, in fact, it's a confusion that you all put up only.
You know, my lord, we have withdrawn that notification also, and it's that our right to do it, my lord. That is
of course.
I will try to endeavor. My endeavor would be to.
They can only do it prospectively. They should have clarified there is really prospectively.
The Lord Supreme Court has settled it retrospectively also. That is the law settled by Supreme Court. Also.
Okay.
I'll place that.
So if we make them retire 58, they have to refund the salary they've been paid. But other
no, my lord, in that cases we have the protection, my lord. If the law is also, your lordship has laid down the law.
Retire us or retrospective, my lord, give us group D post in terms of the memorandum, my lord. They have not given us group D post also, which are reserved for RCW, my lord. If they give that, we are okay with that also, my lord.
The law is very clear, my lord. There will be no refund.
Law, there are so many aspects of law.
Yes.
And only 2 aspects of law in this case. Only 2.
6.
We are filing affidavit when? I'll be filing it, my lord. Now,
because of the day.
No, my lord. They have just implemented the secretary, my lord. I need to take instruction whether the order has been complied or not.
Yes, Mr. SD Senate appearance today on behalf of the implicit respondents. Some response allowed to stand file affidavit here.
What is the next item? Please, Lordship, in this matter, I would like to file the rejoinder, Lordship. Matter went to the mediator, but then we have.
Yes, the mediation, as the mediation, as mediation was not successful, Mr. P.T. Sama pays him to file rejoinder to
Lordship.
affidavit filed by the state respondents of both the
We have filed. Yes, all the respondents they have filed.
To file rejoinder to affidavit filed by the respondents.
Lordship.
Just after 2 weeks, yes.
Lordship.
Obliged, my lord.
8.
Yes.
May it please your lordship. Lordship, we have received fresh instructions, my lord. If I may kindly place the same before this court, lordship.
Who's
I'm for the petitioner, your lordship.
okay.
This pertains to the reservation of the post of inspector, lordship, of Excise.
You put an affidavit then.
My lord, we'll place an affidavit, lordship.
Members NG standard submits that on receipt of fresh instructions we be allowed to file to bring the same on board by way of an affidavit. There is allowed, yes. You give a copy to her also.
We'll file an affidavit, lordship. 2 weeks, my lord. Much obliged, lordship.
9.
Have you pleased your lordship? Lordship, I am appearing for respondent number 6, your lordship. Lordship, we require some more time to file our affidavit in opposition.
What's the matter about?
In this matter, your lordship, we're challenging the
So why was a copy of the order to write petitioner by respondent number 6?
that has already been enclosed in a writ petition, your lordship.
That's WC 148.
Yes, your lordship. In that case, Your Lordship, the Honourable Court has already dismissed that matter, Your Lordship. So they've come to against Your Lordship for the same cause, same issue, for the same issue, Your Lordship. For the same issue.
Your Lordship.
Different
The issue
petitioner,
raised
same
in this
issue,
case
sir.
Is with regards to the ineligibility of the respondent number 6 and the proceedings, Your Lordship.
This is Dr. Aruna Vijay Singh. You are
Yes,
applying
sir.
for number
I'm
6.
for respondent
You
number
have
6,
not
Your
filed
Lordship.
affidavits yet.
No, Your Lordship.
Yes, sir.
My Lord, I'm praying for a little more time.
This is for the Shillong Medical College.
Yes, Your Lordship. Same issue but different petitioner, Your Lordship, in this time.
Go for 6. The giver as you want to file. Brief one out for the 2 weeks time for affidavit. Expected next date you be on board.
Obliged, Lordship.
I will come on very hard on no affidavits. It will take long time. Then we'll call for the records. This time, let officer come and we'll settle the matter.
Yes.
Obliged, Lordship.
Yes, Mr. B.K. Singh, you file affidavit.
Yes,
what happened?
I'm appearing for respondent number 2 to 4, my lord. This last chance may be given another 3 weeks, my lord.
No 3 weeks. We'll give you 2 weeks time. Last chance. Yes.
Lordship, I am appealing on behalf of Aris Mishra. Interim order can be continued.
Yes, Mr. B.K. Singh, brief ones allowed 2 weeks for a time as last period file affidavit stuff. Interim order, if any, shall come in next date. List on so and so. Yes.
11.
My lord.
May it please Lordship. Lordship, the writ is not maintainable, my lord. If Lordship will see that the petition has been filed purportedly by the power of attorney holder, my lord, kindly see page 15, my lord. One five, my lord.
1 second. You wanted to file affidavit. You don't need affidavit now.
My lord, kindly just see, Lordship probably without affidavit also can dispose of the matter. My lord, kindly see page 15, paragraph 1. As duly appointed power of attorney, appointed attorney or petitioner, my lord, and entire writ petition there is no attorney. Power of Attorney Act is governed, and full bench and Supreme Court is very clear that along with the writ petition you have to file, and even Wakalatnama, your Lordship will see at the page 54, my lord, last page, or 47, last page, my lord, there is no power of attorney annexed, my lord. So under the Power of Attorney Act, he is bound to produce the power of attorney, and the full bench of Allahabad High Court has settled this matter that writ petition can't be filed without producing the power of attorney, my lord. So this petition in the present form is not maintainable, my lord. If I can place Power of Attorney Act also, my lord.
Yes, Mr. Zakhar, why? What's happened?
My lord, on the last page of our writ petition, the power of attorney is annexed.
Wait, last page?
I think it must have missed.
This is only Wakalatnama.
17.
30. 47, my lord.
47?
47.
Page 47?
Yes. Right after annexed 10.
Yes.
It's a Wakalatnama, my lord, of the power of attorney holder, my lord. If your lordship will see at the foot of the page, K. Manar, and he is Donbok Manar also. I don't know who is this person, my lord. K. Manar, if your lordship will see, and this is not power of attorney under the Power of Attorney Act.
No, this is they've got
special power of attorney, lordship.
Special power of attorney.
But it has not been served on us, my lord. What is this power of attorney?
No, this is at page 47.
My lord, we have.
I don't serve it.
We must have missed, my lord. I apologize. We must have missed the last pages. I'll serve them a copy, my lord.
Let them serve, my lord. Examine. I will examine then thereafter because
Yes,
I don't.
It appears that the copy of the power of attorney instrument executed in favor of the writ petitioner is not annexed to the petition served on the state respondent stuff. Which council directed to file complete copy of petition to the respondents. Just after 2 weeks for affidavit.
Hello,
Hello,
12.
My lord, I'm for respondent number 7, my lord. I've sent my affidavit for vetting, my lord.
What's the matter about?
Your Lordship, this is regarding the landfill at Nohali.
You're objecting to it?
Yes, Your Lordship.
Their grievances that they was not heard, my lord, and that is not correct.
Yes. Other correspondence.
My lord, I'm appearing for the state respondents, my lord. I'll be requiring some time, my lord, since our
1,
instructions
2,
are
3, 5, and 6. IB Nongrum, IB Nongrum. You have 4. Number 4. Your landowner also there. And 7 is the Muda.
Yes.
So 9 is,
my lord.
you have no objection.
The proposed landfill will be set up in our village.
So you have no objection to that.
We are the beneficiary of that. If the state files the affidavit, then we examine the matter.
Yes, Mr. Jain Ranja, 1, 2, 3, and 5, and 6, or 1, 2, 3, 5, and 6. MS Bison for 4. SD for 7, and I'm going to pre-file out for the 2 weeks time for affidavit. Oh, sorry. Thought I would cut out that one. IPU is Bison. The affidavit of the number 4 is already on board. Yes.
13.
Maybe Lordship. My lord, item number 13 pertains to a dismissal order, my lord. Affidavit in opposition has not yet filed, my lord.
Previous amount time, 3 weeks time.
Yes. When is it filed? Or recent matter? 2 weeks.
December 25.
Item number 14, my lord, I have received the copy of affidavit in opposition. 3 weeks time may be granted to file the
item number
14, my lord.
14, yes. 14. Mr. B. Kumar pays funds allowed 3 weeks time file rejoinder after the status of the respondent. Yes.
My lord. And item number 15 and 16, my lord, affidavit in opposition has not yet filed.
Yes, as prayed for the 3 weeks time.
My lord. Deep lordship.
17.
This matter was referred for Lok Adalat, my lord, on the 14th. So it has come back, my lord.
Lordship.
No, I noticed mostly the petitioner didn't appear. Why you didn't appear?
We appear, lordship. Here, lordship, the matter is very simple, lordship. He was regularized and retired in the year 2021, lordship. So I don't understand the reason why they have not released the pension, lordship. He was regularized, lordship. It is on record.
There's some confusion because the instructions which I received, my lord, it says that 2016 to 21 his service is not regularized.
Can be, lordship.
Require some, my lord, so I'll require some time, my lord, to clarify.
You file affidavit?
No,
No,
lordship.
lordship.
This is a new case, my lord. 2025,
Yes,
26 case.
Mr. Kivu Raji prays funds allowed 2 weeks time to file affidavit. He further submits that he will seek specific instructions
Yes,
in the event an affidavit can be filed by the next date.
Okay.
Yes.
Most obliged, lordship.
18.
Yeah, please, sir.
Transfer petition, lord.
Yeah, on behalf of the full respondent.
Yes, sir.
What's your name?
S.R. Marak.
S. Sangma.
S.R. Marak.
S. R. Marak. Yes, sir. You want to file any objection?
Yes, your lordship, we will be filing my affidavit after 2 weeks.
MSS, probably MSSR Marak, the counsel appearance on behalf of the sole respondent. Such service is complete. She pays for the allowed. How much time?
After 2 weeks.
2 weeks time to file affidavit. Just thereafter.
19.
Lord, I pray for 2 weeks time, my lord, to file affidavit on behalf of the respondents.
Contempt matter, Mr.
Lordship. Yes, my lord, it's almost ready, my lord. Almost ready. Just ensure that it is filed within these 2 weeks.
For the 1 week's time to file affidavit.
10 days, my lord.
10 days makes it more specific, okay? 10 days. Just thereafter and so on.
20.
But I have instruction to appear for 2 and 3 as well, my lord.
3 and 4 as well.
2 and 3, my lord. National Commission for Homeopathy and for 3 also, my lord. Homeopathy
3 and 4.
And for respondent 5, Lordship.
1 second.
So the last order.
My lord, it's primarily now for the respondent number 2 to file their affidavit on what is impugned, the National Commission for Homeopathy. And Lordships, as per the last order, indicated that the affidavit should be on board, considering the urgent nature of this matter. My lord.
Yes, what happened, Dr. Mozika?
But they've dispatched. I'm getting SMS that affidavit is dispatched. I have not received. Maybe today or tomorrow. I'll
Last chance may be given, my lord.
Last chance has no meaning.
10 days time. We'll choose.
So, Dr. Mozika today submits that for now, you're not appearing for 4, but for 3.
Only for 3, I have been told. My lord.
What about 4? 4, you're appearing for?
5, Lordship.
5 is a private respondent.
5 is Nehu. Nehu.
And 10?
10 was we've not served notice.
Yes, what about number 3?
3 I am appearing, my lord.
Of 4, sorry.
I think I can depend 4 also, my lord.
Yes, it's all part of the same.
But affidavit, we are filing for 2 and 3.
Dr. Mozika today submits that he'll be representing all the respondents 1, 2,
1 to 3, and then 6 to 9.
And 6 to 9.
1, 2, 3, 4.
He prays for further 1 week's time or 2 weeks' time to file affidavit.
So it'll be 1, 2, 3, 4, and then 6 to 9.
Yes, 6 to 9. 1, 2, 3, 4, 6 to 9. We're not planning this.
Obliged.
What is hard for number 4 or number 5?
21.
Obliged.
21.
The affidavit is ready, Archie. We will file during the course of the day. Give it to during the course of the day, Archie.
We'll pass orders then. You keep the lien amount 4,900 and defreeze the account.
That's why, Archie, if the state gives us a clearance, cybercrime
We
gives us a
don't
clearance.
need clearance state with orders of the court.
That depends on the state.
Listen, next week
Next week not possible. Week after.
On 1st April.
Lordship.
Yes. Mr. S. Marpan submits that after final course of the day for the matter on 1st April for further orders. Yes. All right.
22.
Archie, this is HDFC Nongstan. One party is added, respondent number 5 here, Archie.
It's also freezing.
This is not freezing, Archie. This is a fraudulent transaction, Archie, which led to freezing ultimately, Archie. I'll be entering appearance for respondent number 5 here, Archie. We just received notice here. So it'll be 4 and 5 here, Archie.
Your Honor,
Yes,
I
what are your
on behalf
instructions?
of the petitioner.
What are your instructions? Have you
We have already filed the status report, which was delivered on for respondent number 5, which was delivered on 10th of March 2026. Your Honor, we need further 1 week's time to file a reply to the status report.
Mr. S. Marpan today submits that he will also be representing respondent number 5.
Yes, Archie.
As such, notice complete all the respondents. What's your name?
Dearest.
Your name?
Dearest Dan.
Didan.
Yes.
MS Didan appearing for the petitioner. You have received this report dated 6 March from the police.
10th of March.
10th of March.
Yes.
10th of March.
For respondent number 5.
Where's the state council?
She's in another court, Your Honor.
State Council, where's MSS Ladu? Who appeared last time?
Yes, Lordship. Lordship, she's unavailable, my lord, today.
Today is not there?
No, my lord.
Then who's standing in her matter?
I don't have instructions, my lord. I'll be appearing for today, my lord.
But you don't have any instructions?
My lord, let the matter come up tomorrow, my lord. In the meantime, I'll just seek instructions, my lord.
No, you got a status report dated 6/3, correct? What 10/3 you talking about?
Delivery of report.
Yes?
I think they're referring to the delivery of the notice to me, to respondent number 5, I think.
No, not notice. There's status report given by the state respondents dated 6/3/2026, correct? What do you have to say on that? That is what is for today. Have you filed affidavit?
Not yet, first
State
day.
not filed affidavit.
Not yet.
No, my lord.
Appearing for the
It's up
first.
for 1 week for the orders then.
Yes.
Yes. Who's your lead counsel?
Olivia Bang. Olivia Bang.
Okay.
23.
May I please, Your Lordship? Your Lordship, we are still awaiting instructions in some
Pension matter?
Yes,
Yes,
family
proceed.
pension, Your Lordship.
When was it filed?
Your Lordship, is the first time after motion, Your Lordship.
Not a personal motion. This is. See, the order is 6/3.
16-2, Your Lordship.
6/3/2026. For a 2 weeks time, allowed respondents 1 and 3 and 4 to file affidavits. How do you see the first time after motion?
My apologies, Lordship.
How does check the last order passed by the court is as paid for a 2 weeks time allowed?
Much obliged, Lordship.
None appears for respondent number 4.
24.
This is also a pension matter, Your Lordship. We were asked to seek instructions from the government. We have received a preliminary instruction, which, for which, Your Lordship, I would like to take Your Lordship to the writ petition, the prayer portion of the writ petition, before I come to the instructions, Your Lordship.
Yes.
In the prayer, Your Lordship, the petitioner has prayed for approval of the initial pay statement as per 2017, then fixation of pay in the 2017 revised pay structure, and for areas and terminal benefits as on the post from which he retired, Your Lordship. But the petitioner, Your Lordship, had been appointed as a work-charged pump operator, Your Lordship, in the year 1988. Thereafter, Your Lordship, in the year 2001, Your Lordship, he was appointed as technician grade 2 without following the rules, Your Lordship. And he was just a pump operator, whereas the technician grade 2 is filled from the post of an electrician, Your Lordship. No rules were followed. It was just done at the divisional level by the executive engineer. Subsequently, again, he was appointed as a treatment plant operator, Your Lordship, again by the same, at the divisional level, by the same officer, Your Lordship. So because of these irregularities, Your Lordship, in his appointment in these posts from which he retired, Your Lordship, there has been some time taken for considering his...
You put in affidavit then?
Yes, we'll put it in the affidavit, Your Lordship, because his
Yangi
appointment
DAG
is
has
irregular, Your
submitted that,
Lordship.
the settlement of the dues of the petitioner. You're the one,
He's the
or the petitioner, who is a retired employee, could not be expedited due to the irregular nature of his promotion.
Promotion or
which occurred to him
appointment.
in the course of service stop. She therefore prays funds allowed
3 weeks' time, Your Lord.
My Lord, just my humble submission, my Lord. My Lord, we have also filed a representation and we have also questioned the department, but the department was silent, my Lord, for all
now
this
they'll
time.
speak. Now it's spoken after the
Lordship's
petition.
clarification has been sought. On the representation given, the department has sought clarification from the division, Your Lordship.
Yes.
We need 3 weeks' time, Your Lordship. Highly obliged, Your Lordship. Obliged, Your Lordship. The next one is also 25.
Who's number 3? Mr. Marpan?
Hello, I'm for
Which
the bank.
is this?
This is Bank of
Canara
India.
Bank. Oh, Bank
of
of
India,
India.
my lord. My lord, we have complied with the order of the Kerala police. They are the same account. There was 2 transactions. Now we have received a communication from the one of the court of the West Bengal, my lord. They have asked us to defreeze it. But again, Kerala police has written to us, my lord, to freeze it, my lord. We are
What's the amount in question?
15,000, Your Lordship. These are all the cyber crime probably, my lord.
Because many accounts now, you see, people don't know also.
Yes, from where the money is coming and where the money is going, my lord. The police will be the correct authority, my lord, to decide.
You are appearing today on behalf
Yes,
of
I'm
the
appearing
country.
today.
Ms. SD
I'm appearing
today
in
appear
one
behalf of
only, Your
respondent number
3.
3.
We don't have much.
As such, notice complete all respondents.
Yes, Your Lord.
Yes, Lord.
Kerala has appeared?
No, only Kerala, my lord.
Kerala police has not.
Yes, Kerala police respondent number
2.
Number 2, Your Lordship.
However, there is no report with regard to served notice on the respondent number 2. Where's order? Where's that from Kerala? This is please account.
Your Lordship, we've already given the service of notice in case of respondent number 3. However, number 2 yet to file the.
Yes, also we recorded that. Yes, where's, let's see what instructions you have, Mr. Day.
My lord, I have one letter, my lord. This is the letter. Only one copy they have given me.
Let us see.
And the writ also, my lord, they have given without annexure, my lord. If they can kindly furnish us the documents.
So we have furnished. So we have given the bank in person.
No, whatever we have received is not proper, I think. Not all the documents has like annexure. Not the verification.
I can give you a copy, sir.
Yes, it's kindly.
15,000 only. So that was son, Mr. Rafiq. It was debited from his account.
Commission from the banks.
Even if you release, the police will make us a party.
No, it's not that. You see, the thing is that now he has an account in your bank, correct?
My lord.
Now that amount has been credited to the account repetitioner, and so you will have the details of the transactions that have occurred in his account.
My lord,
That's the only thing.
Yes.
So apart from, you can defreeze it, apart from just keeping that amount deposited into your account.
Yes, it has been debited.
Then you secure the amount, the other amount that is operated account, but then you cooperate with investigation and you give the details. Whether he has any UPI in transactions, any bank transfers, which is that. That's all.
What is his role also? That also police will examine. What is his role also? My lord, police need to examine.
Of course, they'll examine.
Will.
As far as we are concerned, we don't have any role to play because we have not received any complaint.
From this honorable court, my lord, we can defreeze it. We have no problem, my lord.
But you are submitting that there's another order asking for defreezing. Where's the order?
That my lord, I need to get a copy of it. They have just verbally informed me from Calcutta, my lord. The police, the PI has
connection to the same offence.
Yes, my lord.
You're absolutely certain about that.
Yes. So I will complete the instruction also, my lord, on the next date, my lord.
Mr. SD, enter appearance in behalf of number 3 and submits that as per limited instructions. As per limited instructions, the NCRP complaint had been registered at Kerala, whereby Kerala police had ordered for freezing of the debit freeze of the account of the writ petitioner. So our please be allowed to obtain further instructions. How much amount is stuck in your bank?
The remaining amount is around 90,000 and the disputed amount is 15. That has already been debited.
Yes, sir. Just up to 2 weeks.
But the entire amount has been frozen.
What I could have understood over phone, my lord, there was 2 transactions.
You bring that on record because we can't pass effective orders.
This is the only copy I will also supply.
The state is represented, Your Lordship.
Yes, we record it.
Elijah.
Supplementary 1, item number 1.
With all 3 EWS category, my lord. These people, my lord, pharmacist, radio mechanic and draftsman, my lord. And in fact, pharmacist, my lord, in fact, since lordship had asked about the post, actually, pharmacists, these people are actually to move into unreserved category, my lord, because they have scored more marks than the reserved category. Sorry, the UR highest marks, my lord. So therefore, the post to be kept vacant is an unreserved post, my lord.
Yes, you take instructions.
My lord.
Yes, sir. So, issue notice Dr. Mozika which was present. You are selected otherwise.
Otherwise selected, my lord.
Yes, Dr. Muzika, anything to say?
Otherwise qualified, not selected.
I would have Mr.
Sorry, not selected. You can't keep the post now. Yes.
Come together, my lord, with other matters.
My lord.
Let's call for 2 weeks.
My lord. And the same order.
Don't tell them order, but yeah.
My lord, there has to be, my lord. Otherwise, my lord, because the entire exercise is apparently long, lordship has seen. They have probably thought it as a horizontal reservation. So they've just filled up one post in its category.
Yes.
But then the UR, my lord, they have not, because UR people are scoring lesser marks than us, my lord.
2. 2.
2, 3 similar.
Or EWS. Similar.
EWS, my lord.
But what trade are they?
2 is, my lord, radio mechanic. Okay. And 3 is, my lord, draftsman.
Okay. OBC. Yes.
Hearing.
Obliged.
Supplementary. 7.
Violation, corrected one, you given to give to the court. Given. Me, please, your lordships. No, my lord, I have corrected this compilation.
Corrected it?
That. In fact, yesterday I have concluded up to maintainability, my lord.
But I thought now it's 6 or 7 first.
6, 7. But I have not concluded my submissions.
Oh, sorry.
Now, my lord, so for maintainability part, my lord, I have relied on certain judgments, your lordships. One of the leading judgment of Supreme Court also, your lordships, paragraph 38. And one judgment, my lord, somehow inadvertently not included. I have, but that is very close to the facts of this case. That is a judgment, my lord, pertaining to Nehu only by the Guwahati High Court. Now, my lord, that is at page 39 of the compilation.
The fresh compilation?
Yes, page 39.
This one you given today?
Yes, madam. Page 39 of the.
If a copy can be given to me also, I will know.
Page 39 of the compilations, my lord. Now, if I can read my lord.
It's the same judgment?
No.
The same petitioner?
Same petitioner, my lord. That's how the confusion came, my lord. Because he filed a number of cases these days. Xavier Mo. Now, my lord, the facts, if your lordship look into it in the opening paragraph, in the writ petition is questioning the legality of appointment of the professor of culture in the Department of Philosophy. At the very outset, it may be noted the copy of the imperial order is not even annexed. It is considered then the London Council opinion for the university that the petitioner is not even a contender for the post in question, as such, has no locus standi to file this writ petition in support of his contention. He relied on this judgment. Now, my lord, will come to paragraph 2.
Yes.
Before adverting to various contentions raised by the petitioner in his writ petition, it will be appropriate to examine the standing of the petitioner to challenge the validity of the impugn appointment. This is necessary. If the petitioner is found to have no standing to file the writ petition, I need not deal with the other points so raised by him. My lord, these, my lord, why I am, my lord, emphasizing on this, what we are saying, your lordships, that if he is unable to cross the first hurdle, then my lord will not go into other things. Now, this judgment, your lordship, if you, my lord, come to paragraph, page, my lord, if your lordship come to page 40,
Nothing.
page 40, my lord, paragraph 3.
Yes.
My lord, the Honorable Court relied, my lord, I have relied that paragraph 38 of Supreme Court judgment. This Supreme Court judgment has been quoted, my lord, in paragraph 3.
That is Kadir.
Kadir, my lord. Right? And ultimately, my lord, the finding of the learned single judge, your lordships, at page 43, paragraph 8. For the reasons stated in the foregoing reason, the petitioner has no standing to maintain this writ petition, which is hereby dismissed at the threshold. Consequently, it is not necessary to examine the merit of the case, as projected by the petitioner in his decision, considering the fact that no parties fear to the post. So my humble submission, this catenary of decision in service matter, my lord, the law is very clear and categorical. There is no exception. One exception, writ of quorunto. Writ of quorunto, what is sine qua non, my lord? Public office. Admittedly, my lord, the Karnataka judgment, that was also in relation to teachers. Quorunto was sought, my lord, with regard to, my lord, cancellation of appointment of some teachers. Then the court has held in that case, my lord, they are not holding any public office. And the writ petition was not only dismissed, dismissed with cost. That case. Now, my lord, I will go to the other points. Now, my lords, before, my lord, on merit, my lord, whatever contention rights, my lord, I have jotted down. Now, my lord, many of the, my lord, issues raised by my learned friend, my lord, are not based on any pleadings.
Not based on?
Are not based on pleadings. No pleadings were made.
Yes.
And in fact, my lord, in the course of hearing, there were queries from this court where the pleading, if there was any pleading, my lord, in this respect.
Yes.
There were two answers for my learned friend. One is, with respect of certain information, RTI filed, but RTI information was refused, and perhaps, my lord, at the advice of the council. That's what he said. My lord, this is nothing, my lord, but character assassination. That doesn't help me to improve his case. No, let me complain.
No, my lord, that will taint me that I'm alleging the previous counsel. That is not correct, my lord. I said the RTI was not furnished to us. Even my marks was not given to me, my lord. I have said I don't want to comment about what was the advice given to the previous counsel. Yes, please don't comment.
That doesn't help, my lord, character assassinations. Now, my lord, suppose RTI was refused. Now, RTI Act is very clear and categorical. Against the refusal, you have two tiers of appeal. You have not gone for appeal. You have not advised your client to go for an appeal. How it helps? This is one thing. Other thing is this, that I have entered into this case now, my lord, in the middle of the proceeding. Certain issues, regarding certain issues, my lord, pleadings were not taken up. Now, my lord, here also, my lord, what stopped you, my lord, by making a suitable amendments? You have never made an attempt. This matter is pending, my lord, for quite some time. You never made any attempt, my lord, to amend this writ petition.
Yes.
Now, my lord, first and foremost, my lord, what my learned friend said, that there is serious problem with qualifications. They do not, 6 and 7, do not possess the requisite qualification. In spite of this, they were, my lord, shortlisted and they were considered by the selection committee, recommended appointment. So the appointment should go, my lord. Now here, my lord, if I can, that regulation, if I can take, my lord, what are the qualification? Admitted position is this, my lord. This particular selection is governed by UGC regulation of 2018.
Yes.
Now, what is the qualification laid down?
Yes.
An eminent scholar having PhD degree in concerned law, she will take note, allied relevant discipline, and published work of high quality, actively engaged in research with evidence of published work, with a minimum of 10 research publication in the peer-reviewed or UGC listed journal, and the total research score of 120 as per the criteria given in appendix to table 2. Number 2, a minimum of 10 years of teaching experience in the university / college as assistant professor, associate professor, and or research experience at equivalent level at university, national level institution with evidence of having successful guided doctoral candidates. Now, my lord, here your lordship, though they have pleaded, my lord, a case that normally, my lord, you should have a master degree in geology to be qualified, my lord. No such criteria has been prescribed. What is relevant here? PhD degree in concerned, allied or relevant field. PhD is the requirement. It's immaterial, my lord, in what subject you have done your MSc. That is not a relevant consideration at all. Now, my lord, other thing is, my lord, research and academic works. Now, research and academic works, my lord, after the 2018 regulation, my lord, the marks has been standardized in appendix 2, table 2, my lord. Standardized. For this quality of journal, it will call it this marks. This quality, this marks, my lord. Standardized. And applications are supposed to be filed online. On the basis of the, my lord, research works, my lord, the marks are generated online only. No more it is manual. Now, my lord, so far, respondent number 7 is concerned, my lord. He qualified to be considered for appointment by virtue of A. He has the PhD.
Allied.
My lord. Now, my lord, concerned, allied, relevant. Now, admittedly, my lord, he's done his master from biotechnology. In the department of biotechnology, he done his master. Now, biotechnology is also a, my lord, department under the same school, School of Life Science. And as I said yesterday also, your lordships, these are all related. Bio, my lord, the prefix bio, your lordship, literally mean connected with life. Zoology is also a study of life, life of animals, their classification, evolutions. Now, biotechnology also relates to life. So, to what extent they are relevant, allied and all, my lord, beyond this, it is very difficult for us, my lord, to decode it. It is for the expert. If they had a real problem, my lord, they should have made the expert as a respondent. They could have come forward before this court, file an affidavit. Now, my lord, so far, he has other requirements also, my lord, like, my lord, PhD, then post-PhD, my lord, guidance. He fulfill all this. Now, coming to, my lord, B, this is the alternative qualification. Now, it's say, my lord, an outstanding professional having PhD degree in relevant, allied, applied discipline from any academic institution and not included A above, / industry who has made significant contribution to the knowledge concerned, allied, relevant disciplines supported by documentary evidence, provided he or she has 10 years of experience. Now, my lord, it has two parts, if your lordship look into it. An outstanding professional from a...
But see, not included in A above, that means he should not be from university.
Lordship, I'm just coming to my lord. Yes. It has two parts, my lord, I'll say. One is a professional having PhD from a academic background, but not involved in classroom teaching.
Yes.
There can be academician, my lord, without classroom teaching, who are involved in research work, publication of papers, but not teaching. That's why, my lord, they have said not included in the A. They are specifically speaking about, my lord, what is the experience? Teaching in the class, guiding research scholars. That's what they are saying. B is not saying so. B is saying an academician, but you are not teaching as ever. But you are involved in research. Then, my lord, / or industry. Now, when it comes to industry, of course, my lord, you are not from academic background. It's purely technical things, my lord. You are not academic background, or you could be from an academic background, industrial background as well. That is a non-academic background and should have 10 years experience. Now, these 10 years experience, what my learned friend said, that so far, because, my lord, respondent number 6, he qualified by virtue of B. Now, my lord, so far, respondent number 6 is concerned, he did his PhD in 2015. Selection was held in 2022. So they are saying, my lord, after PhD, where is the 10 years? Now, my lord, what this provision is saying, it is not saying that post-PhD there should be 10 years. PhD is one of the requirement. What it is saying, your overall experience should be of 10 years.
Is that the definition? Is that the interpretation?
That is the interpretation, my lord.
But usually it's after PhD, then you've
No,
done for 10 years.
PhD, my lord, after PhD.
Usually it's like that. Suppose you to be eligible for associate professor also. You have to have 10 years after PhD, then you have to be a guide also for certain number of students.
My lord, that is
I might be wrong, but
no,
that's
it's
a standard.
No,
that's a standard, I think.
That is standard. But now, this is something introduced for the first time, my lord. They have brought in industry also. They have brought in, my lord, academicians who are not involved in teaching. What my lord is saying is correct. When it comes to classroom teaching, then guidance and other things, this has been taken care of in A. B is in deviation from A. This is not the, my lord, normally what is the lordship is saying correct. If you are involved in classroom teaching, then all these things come. But this is something introduced for the first time. It was not there before 2018. They have created an avenues for academicians who are not involved in teaching.
So
and
for experiences overall.
Yes. And also for those who are coming from industrial background. That means non-academic backgrounds. So my humble submission, my lord, this qualification is a new qualification added for the first time under 2018. It was not there before. So my lord, he fulfills. The post-PhD experience of 10 years is not a requirement. Classroom teaching is not a requirement. Now, how he is a professional, my lord, that is for the expert, my lord, to decide on the basis of his publications, academic, research works.
Yes.
So now next, my lord, flag of submission. Yes. Now, my lord, they have relied on a particular clause, my lord, that is at page 76.
Authorized petition?
My lord. No, lordship, in the same regulation. Same regulation, page 76. Please, Rule 6, Regulation 6, Clause, my lord, 5.
Yes.
Now, my lord, it say, in case of selection of faculty members who are from outside academic field, lordship will take note of that, and are considered under 413B. That's, my lord, I have just read it, 3B. 42, my lord, these are not relevant, B. Of this regulation, the university statutory bodies must lay down clear, transparent criteria and procedures so that only outstanding professionals who can contribute substantially to the university knowledge system are selected. This is clearly, they say, for those who are non-academic, who are coming from industrial background. As I said, my lord, clause B, there are two categories of candidates. One from academic background, other from industrial background. If it is industrial background, then criteria has to be laid down by the academic council or executive council, whatever it may be. These are the criteria. Here, admittedly, academic council has not formulated a criteria because that is not required. Because he qualified by virtue of the fact, my lord, that he came from an academic background with research work and PhD.
Yes.
Now, my lord, other contention, my lord, specialization. Now, my lord, in the advertisement, it's true, my lord. What are the specialization they have spelled out? No, nowhere in the rules, either in the UGC rule, regulation or the advertisement, my lord, has spelled out that specialization has to be considered on the basis of a certificate. It's very broad, as I have seen, my lord. What is the requirement, my lord? An eminent scholar having a PhD degree in relevant fields, my lord. Lot of scope has been left for, my lord, understanding this to the expert. And what is the specialization? Not on the basis of the certificates. Yeah. So, my lord, whatever, my lord, the relevant subject they have done the PhD, my lord, they have mentioned it. And even, my lord, if your lordship wants, my lord, the subject in which they have done there, I try to decode. It's very difficult for us. Try to decode that. My lord, that covers, my lord. Even my understanding, my lord, these are related. Now, what is the specialization, my lord, has to be deduced from the subject in which they have done PhD. their research and academic works. And it can be deduced only by the expert, my lord, not by us.
Yes.
And if your lordship here, I will just point out, because they are saying all those things, biotechnology, bioinformatics, this is aligned to zoology, my lord. That's I have pointed out, my lord. The Reed petitioner is saying so, your lord. Reed petitioner, who himself is from zoology, he started his career as an assistant professor in the Department of Biotechnology, Manipur University. And there is nothing wrong in it. But saying that they are aligned, my lord, that is wrong.
Yes.
Now, my lords, in fact, your lordship, briefly, what is, my lords, with reference to the specialization, if my lord comes to page 3 of my compilation, I have briefly, my lord, I have referred to the source also. What are the definition of all these, my lord? Lordship can briefly refer to it.
Page 3?
Page 3 of my compilation.
Okay.
My lord.
Yes.
All right. The general definition. Now, my lord, the main branch of study here is biology. Biology is the study of life science.
Yes.
Scientific study of life and structure of plants and animals. That is as per, my lord, my understanding, and I have quoted it from Oxford Dictionary. Now, biochemistry, scientific study of chemistry of living organism. Now, biotechnology, my lord. Branch of technology concerned with the forms of industrial production and use of microorganism and their biological process. So all this, my lord, as I said, my lord, the literary meaning of bio is connected with life. All relate to life, but to what extent relevant, my lord, I don't want to comment on that. Now, zoology, scientific study of structure, form and distribution of animals. Now, on the next page, if I can take, my lord, because these are concerned with the specialization, molecular biology and biosystematic. Now, what is molecular biology? It is a branch of biology that studies structures and function of essential cellular macromolecules, specifically nucleic acids and proteins, to understand biological processes like inheritance, genetics, cell function. It often focuses on molecular basis of general function and protein synthesis. So these are all, my lord, related to study of life. And as I say, zoology is a study of life of animals, your lordships. And biosystematic, my lord, if your lordship look into biosystematic, taxonomy based on cytogenetics and genetics, focusing on the classification of organisms through the study of their voluntary evolutionary relationship and variations. It is filed the combined biological data and systematic categorizations. Now, my lord, if your lordship look into it, if your lordship want, my lord, what are the specialization, again, I can take, my lord, in the advertisement of their affidavit of the writ petition.
Okay, come to composition of screening committee.
Yes, sir. So, my lord, this is special, but then just if I can conclude this part with some judgments, this is there in the compilation, then we will go to the next, my lord. Let me complete. So, my lord, this is something, my lord, we cannot, but basic layman understanding, these are related to life. The rest is for the expert, my lord. Now, my lord, there are two judgments, my lord, on opinion of expert. Leading judgment here, my lord, 1963 SSU online, my lord. Paragraph 11, my lord. Paragraph in a page 119.
Mysore University.
Yes, my lord. This is, even now it is referred to. These are 5 judges. Para 11.
Yeah.
In our opinion, in coming to the conclusion that the appellant who did not satisfy the first qualification, the High Court is plainly in error. The judgment shows that the learned judges concentrated on the question as to whether a candidate obtaining 50% of the mark would be said to have secured the second high-class degree. And if the relevant question had to be determined solely by reference to these aspects, the matter, the conclusion of the High Court would have been beyond reproach. But what the High Court has failed to notice is the fact that the first qualification consists of 2 parts. The first part is a high second class master degree of an Indian university And the second part is its equivalent, which is an equivalent qualification of a foreign linguist. The High Court does not appear to have considered the question as to whether it would be appropriate for the High Court to differ from the opinion of the board when it was quite likely that the board may have taken the view that the degree of Masters of Arts of the Harvard University which the appellant to had obtained was equivalent to the high second class degree of the Indian. These aspects of question purely an academic matters, and the court would naturally hesitate to express a definition opinion, particularly when it appears that the board of experts was satisfied that the appellant number 2 fulfilled these questions. So, my lord, that's what I am saying, my lord. These we cannot decode it. As a layman understanding, my lord, what the dictionary meaning is, this appears to be irrelevant.
No, right, you made a point, yes.
Once, my lord. Similarly, I will not read it 2001 and 19 just to show that they have reiterated the principle laid down in the constitutional bench judgment. I have annexed this, my lord. Now I will go to, my lord, the screening committee. Now, admittedly, my lord, the screening committee, there was not a whisper in the original petition, my lord. It is only, my lord, after the conclusion of the hearing, lordship has given them an opportunity, my lord, and they have filed it. Now, my lord, lordship need to understand, my lord, selection of teachers is strictly governed by, my lord, UGC regulation 2018. Now, UGC regulation lay down what are their required qualifications, number one. Then they lay down what is the composition of the selection, not screening, selection committee. That has to be strictly as per the requirement of UGC, my lord. They are totally silent about, my lord, screening committee. Because what is screening committee? There is a world of difference between selection committee and a screening committee.
You may screens the application.
Exactly, my lord. Now, screening committee is something, my lord, which is not provided in the regulation of 2018. This is purely an internal thing of the university, internal thing of the administration, my lord, to sort out the application received.
So that means that screening committee, that whatever OE, whatever mandating the HOD.
No, I'll come.
Part should be the chairman of the screening committee. That have no relevance.
No, my lord, I'll come. I'll come to that also. Yeah. Just for better appreciation, my lord, what I am saying. Now, my lord, this is the role of the screening committee. This is an internal administrative, my lord, initiatives to shortlist the candidates, because pursuant to an advertisement, my lord, hundreds of application comes. There are some bogus applications, some are not duly filled. All these things. These are to be
questions that fine. Yeah. Once you have a screening committee in place, it should be as per the
exactly. No, I'll just, my lord, I'll not skip that. I'll not avoid that.
That now you are arguing
that, your lordships I'll come.
Might be that
yes, I'll come.
The UGC regulations which are governed by silent on screening committee, so it's not. I mean, it's not mandatory that you.
Yes, I'll come, my lord. Now, my lord, there is the role. Now, screening committee do not award marks. They do not conduct interview. They have eligibility. They only shortlist, and after they are shortlisted, then this is placed before the selection committee. It is for the selection committee. They may reject all the applications, not happy. It's for the selection committee. Now, my lord, for the purpose, though it is the internal thing of the university, nothing to do with UGC, my lord, we have, as per our ordinance OE4, give me the ordinance, OE4, provides for, my lord, constitution of a selection committee, my lord. OE4, my lord.
Where is the day reading? From which part?
OE4, my lord. OE4 has different, my lord, subclauses. 1, 2, start with vacancies, mode of advertisement, then, my lord, personal contract, fees, 5.
Except
this will come under B, my lord. Screening of application. If you lost,
no, where's the ordinance?
That affidavit, the last affidavit that I have filed, my lord.
Yes,
madam. Now, OE4, your lordship, look into it. This vacancies, then it's come mode of advertisement, personal contact, fees, procedure of scrutiny, my lord. Administrative scrutiny, then B, screening of applications. Now these I'll read it. The application of all candidates for the post of assistant professor, associate professor, professor, or equivalent post shall be forwarded by the university office to the head of the department concerned, who shall ordinarily, Lordship will take note of this word. It's not that all situation he should be the chairman. Who shall ordinarily be the chairman of the screening committee. However, if the head of the department happens to be an associate professor, the application for the post of professor or equivalent shall be forwarded to the senior-most professor in the department, failing which to the dean of school or the vice chancellor. The head of the department shall constitute a committee of not less than 3 teachers in the department, not below the rank of associate professor, including professor in the department or from the department, other department in case there are not enough faculty members in the department to screen the application for the post of assistant professor, associate professor and equivalent for preparing the list of candidate interview. Now this is important, my lord. Similarly, a committee shall be constituted by the head of the department or senior most professor or dean of the school or the vice chancellor. The options have been given, as the case may be, for scrutinizing the application for the post of professor or equivalent. These committees shall comprise of, now Lordship will take note, shall comprise of not less than 3 teachers. At least, my lord, for quorum we require 3 teachers. And shall include all professors in the department, at least 1 professor from another department in the school or other school. Professors who are re-employed, they cannot be inducted. Now here, my lord, what my learned friends say, in every case, it is the head of the department should be chairman. It's not like this, my lord. The options are there. It can be either him or the senior most professor, or it could be the dean of the school, or it can be the vice chancellor. Now,
similarly, you mean that word
yes.
similarly means, okay.
Now, my lord, similarly, this is for the professor. Similarly means for the post of professor. Lordship will see, this is clearly said. Similarly, a committee shall be considered the head of the department, senior most professor.
Yeah, post professor, yes.
This is for the post of professor, my lord. Now,
Yeah,
here, there's what. Now, my lord, it's not that in all cases it's mandatory the head of the department should be the chairman. Is it ordinarily? It can be otherwise also, who can constitute. Now, here what happened, my lord, in this case, when these applications were received, the senior most professor in the university, I mean in the Department of Geology, was Professor Saha. And Professor Saha was also holding the post of Dean of the school. Now, he being the Dean of the school, my lord, and being the senior most professor, going by the protocol, your lordships, the head of the regular head of the department, he was a junior to him. The vice chancellor has constituted the committee, my lord, making the Dean of the school, who is the senior most professor,
to chair it.
It's for the protocol. Now, my lord, what grievance you can have? This is provided here. And this is not constituted by anybody else. It has been constituted by the vice chancellor.
Yes.
Now, my lord, his problem is we have not included, because the requirement is also the quorum, my lord, 3. They say at least 3. So quorum is 3. If there are 3 professors, my lord, it is good enough, my lord. Whatever decision taken by the screening committee, that gets true. That is the requirement. Quorum is 3. Now he is saying that there is also a mandatory requirement to induct a professor from other department. That was not done by the university. Now I'll explain your lordship why. Now, my lord, if I can take to the last part 9 of the same ordinance. Notwithstanding anything above, any notification in this regard issued by the UGC, Ministry of Human Resource Development, Government of India, and university shall be applicable. In spite of the arrangement we have made, my lord, if there is something otherwise provided in a notification for UGC and MHRD, that will prevail. Now, in 2018 regulation, 2018 regulation, my lord.
It does not talk about screening committee.
Not only that,
So, yes.
it speaks, my lord, why you have inducted a director, because in this case we have inducted a director of a particular cell. Now that is under the guidelines of the UGC. In the matter of, my lord, they say in the matter of, my lord, selection, you should create this kind of cell and involve them into it. That, if I can take, my lord, to the regulation again, 6. At page 75 of the UGC regulation. 6. Page 76.
At 5.
7.
7.
7.
7.
This is under the heading, my lord, selection procedure. Now these are guidelines for selection procedures. No,
Yes,
7.
6.0.
6.0, my lord. Clause 7.
Internal IQAC.
Yes. Internal quality assurance cell shall be established in the college as per the UGC national etc. guideline with the vice chancellor chairman, principal chairman. The IQAC shall act as the documentation and record keeping cell for the institution, including assistance in development of assessment criteria, methodology performed based on the regulation. The IQAC may also introduce wherever feasible the student feedback system, NSC guidelines, rational, etc. Now, my lord, here they are clear indication in assessment mode and all. You should have a cell and you involve them. Now, my lord, pursuant to this, university has created a cell. Created this cell, and the director of this cell is one Professor A.S. Dixit. A.S. Dixit, madam. Professor A.S. Dixit, who happens to be also a professor from the same department. From the same department, madam. Zoology. Now, my learned friend said his name appeared twice, my lord, because he was a professor of the department. Then he was a director of this cell also, my lord, which, my lord, as per the UGC guidelines, was to be involved in it. So we have involved him at least in, my lord, to make things fair and more fair. We have involved him in the screening committee. Now, your lordship, 9 categorically say, my lord, in spite of anything, my lord, any direction guidelines issued by the UGC, that cannot be ignored. So we have not ignored, we have inducted him. The quorum is 3. There are more than, I think, 5 professors signed the proceedings. I have, my lord, the copy of the proceedings, if your lordship wants, I can place it. 5 teachers, quorum is 3, signed by 5. So, my lord, as I said, my lord, screening committee only they short out the applications. And then they place, perhaps my learned friend will say, on the basis of merit. Now, of course, it has to be placed on the basis of merit. Now, that question will come, my lord, how they can decide the merit. Obviously, they can. As I said, my lord, now the marks has been standardized. This is reflected in their application, online application. This is generated by the computer. Now, as I said, 7 over 2000 marks, research and academic activities. Now, read petitioner, my lord, poor 600. Distant 600. So, obviously, my lord, who got 2000 in the list prepared by the screening committee, my lord, we will place him in the top. So, only on the basis, otherwise, my lord, interview, other thing, recommendation, suitability, we have no hand. This is purely an internal thing. Then, how it is placed before the selection committee. So, my humble submission, what my learned friend is saying, that screening committee wishes. Now, my learned friend has referred to some decision, Bombay High Court. My lord, recently, my lord, is a very landmark judgment, my lord, where the Kerala University's vice chancellor was removed. There, the Supreme Court has elaborately discussed that if there is a deviation in appointment of the VC, if there is a deviation from UGC constituted search committee or my lord, selection committee, that will vitiate. Here, the screening committee, my lord, and we try to comply, my lord, taking into consideration the guidelines of the UGC. And this is purely an internal thing. And lordship, other thing lordship will look into it. How he can be prejudiced by this committee? It's not that he has been left out. His name also has been recommended. It's not the case that he has been left out by this committee. Now, what is his grievance?
Yesterday,
No, what is his grievance? He wants that the screening committee should have left out 6 and 7.
Yes.
My lord, the other thing I don't know, because my learned friend over many days, my lord, he has, because this has been reflected, otherwise lordship can ignore. He has referred to certain ordinance of the university in his first hearing, because I jotted down, regarding, my lord, on allied and cognate subject referred to in regulation RA4. But he has never argued now, my lord. So, my lord, if he is still insisting on that, my lord, I have an answer.
No,
because of a regulation.
That's here, Mr. Changre. So,
yes. Then, my lord, before I conclude, your lordships, my lord, now, my lord, of course, lordship's pointed query yesterday was to.
that question still remains whether
yes,
you can have
yes,
two
yes,
sections.
that
is what
that is
the court is.
Now, that is, my lord.
Even though, okay, he might have a toehold also to
Yes.
challenge it, but the thing is that for all transparency, whether
Yes.
you can have two interviews, one for OBC and one for general
Yes.
candidate.
Yes.
How is that permitted?
Right, I'll just come to that. Now, my lord, 2019 decision referred to by my learned friend, my lord, that is with regard to Himachal University. I have gone through it. Now, the Himachal University is a state university following the UGC norm. They are not under the control of UGC. And there the fact was this, your lordships, a contentious issue arose between two reserve category candidates. Both belong to OBC. Now, the person who approached the court, his contention is this: I also belong to OBC category. Now, what happened? That for research, and those days, my lord, the markings were manual for research and academic activities under 2010. What happened? My inadvertently, though I have not applied for general category, my record was placed before the committee for general category. And general category, they have entered some marks. But when I was interviewed by the committee for reserve category, subsequently I was held to be ineligible, not qualified. Other respondent, my lord, who was has been declared qualified. Then on RTI obtained the records, I found that no marks for research and academic work has been allotted to me when the interview has held for reserve category. Now, Supreme Court, this is a serious lapse where you are holding to. That is not fair, very unfair. But there also, Supreme Court, my lord, all the appointments made, except these two, my lord, reserve category candidates, appointment of two reserve category candidates, all other appointments, that question comes. So, we will not interfere. Whatever appointment has been made in pursuant to the selection, we will not touch it. And they have made a general thing, this is not fair. Now, my lord, that is a state university. Now, here is admittedly a central university. Now, EGC is very concerned, time to time they issue guidelines, regulation. They are very concerned with implementation of reservation for reserve categories. Time to time. 2006, they have issued a regulation.
Yes.
Clearly, they spelled out in the guidelines. Clearly, they spelled out that interview should be done separately.
Where is that?
I'll just place it. Now, my lord, following the guidelines, my lord, we cannot deviate from them. Following this guideline, we have.
Okay, let's just rewind a little bit. Now, whether one candidate can apply both under unreserved and OBC,
cannot have
two separate applications.
Has to. Why I am telling you? Then I will have to go back to that digital India. What happened after digital India? Thing has substantially changed. Now, what happened while after
common understanding is that fine, you can apply in the reserve category only if you're reserve category. So you'll not come under because you do not come under reserve. Correct? Because if you that the judgment that's funny, whatever. Now the thing is that you apply, suppose the ST, you tick the box, right?
Right.
An SC candidate and your application goes through screen and then you appear in the general examinations.
Okay.
Okay, and then suppose you do better than unreserved candidates, you will go higher. Maybe you'll take you only go to the 7% reserve first, right?
Okay.
Now, whether you can apply in one application, you write, like you're unreserved, and the other application you file, you tick like your OBC or your EWS or your ST. Is it possible to put in two applications?
There has to be like this. Why you just?
Why?
I'm just coming, my lord. No, digitalization. After digitalization, my lord, there cannot be, my lord, any physical submission of form.
Right, but then
no, I'm just coming, my lord.
There's another case also here where in my court because
yes, just now, my lord. Yes, I was observing it.
The person forgot to tick a box with regard to whether he's a sports person or not. And so there was a quota in sports persons. He was a sports person, but because for to tick, he was out. And now, but is it possible you put in two applications and tick in one you tick your
General.
OBC, the other you leave it blank.
It has to.
How?
I'm just coming to that, my lord. Now, your lordship, what happened, my lord? So, for reservation for teachers in this kind of institution, Government of India has formulated an act. We'll just place this act. An act has been formulated. And as per the act, entire university is taken as a unit. And reservation is based on the post. If the post is earmarked for a reserve category, it has to remain with them. But it cannot go to anybody else. Now, other thing is this, with the digital India, my lord, UGC has introduced, my lord, what is called, my lord, uniform, my lord, online platform for submission of forms. Now, it is formatted in a way, my lord, that a single application will go. If you, my lord, want to apply for general, you will have to, or if you want to change, there is a provision for changing it from general to OBC, OBC to general. But there is no provision, my lord, where you can apply for both.
Yes.
It is not there.
How do you apply for both?
I applied for both because it has to be, my lord. Because I also want to, my lord, apply, because since I am from a OBC background, my lord, I want to apply for the, there one post reserved for the OBC. I want to apply for that post. Now, my lord, I also applied for general because as per the format, my lord, one application at a time, general. And then I have applied, my lord, and other thing is also there. Then I have also applied as a reserve category candidate. Now, the reason is otherwise also, my lord. Now, as per the UGC regulation 2018, my lord, when a general category candidate is interviewed, the composition of the changes, slightly changes. But now the requirement is you need to induct.
So you mean UGC adopt different standards when it comes to interviewing for a certain post? Suppose you're a OBC or a ST candidate, a different interview board, and for a general candidate different.
It's different, my lord. That's a fact.
And how can they be how can they reconcile the marks? Bring some uniformity for selection. So OBC is totally on its own. The UPSC is supposed tomorrow decide the same thing. For 7% of the reservation for scheduled tribes, suppose there'll be a separate interview board. That chunk of posts which are reserved for. That is
all right, my lord. I understand UPSC, but here if it is, but this is the thing because of the, my lord.
How is it workable?
UGC directives.
Yes.
Appointment of teachers is not rank based; it's post based.
Okay.
UPSC is rank based according to your rank.
Right.
But appointment of teachers, it's post based. That's the difference. There's no ranking now. Suppose there are two general post work and two people apply and they get through. Now it's not based on the scope. It is on
Just give me that UGC Act.
Joining seniority is counted on a basis.
No, that yesterday that act you have taken up.
That's the difference.
No. No, my lord, there is a act, my lord, reservation of that. I'll just place it before like. Now it categorically say now it will be post based. I'll just place that. You see that yesterday she has taken out Saha. Now, my lord, it has to be post based.
So there's no question of suppose an OBC candidate who does very well, occupying the unreserved post.
No, if it does,
unreserved means unreserved. Unreserved means for everybody. If that's the understanding. Right. Unreserved means unreserved for anybody. A, B, C, D category, whatever.
Yes.
And reserve categories are different.
But then if you are in a reserve category, then since it is post based, you have to be considering.
The other case that came up in the morning only.
Yes.
He was EWS. Right, just analogy. Now his marks were more than a unreserved candidate, but he still was placed in the EWS, and because his marks, other EWS scored more, he didn't get appointment. When his case was that, look, since I've scored more than the general candidates, so I should be placed in the general list, which stands to reason.
What is that?
Yes.
There is an act. Saha has found out yesterday.
It becomes like
now, my lord,
it kind of a paradox. Yes.
Now, my lord, so for the universities, your lordships, university are concerned, my lord. Yeah. Yes. Now, my lord, if I can refer, my lord, there is an act which called the Central Education Institutions Reservation in Teacher Cadre Act 2019.
Very interesting.
2019.
Yes. But outside UGC regulations.
This is outside. Outside means what? This is for applies to all central institutions.
Okay.
Now, my lord, 3, if your lordship look into section, notwithstanding anything in any other law, well, this is a special law, any other law for time being in force, there shall be reservation of posts. The reservation is against the post, my lord. In direct recruitment out of the sanctioned strength of the teacher cadre in the central institution extent and in the manner in which they may be specified by the central government notification in the official gazette. The purpose of reservation of post central education institution shall be regarded as one unit. So 2 new things, my lord. In spite of any other thing in any other law, my lord, this is a special law. Reservation based on the post. If the post is earmarked, my lord, somebody is applying, he has
So
to.
if it's unreserved post, good unreserved candidate only.
Yes. This is reserve. No, I say if it is a reserve post. No.
It defies logic.
If it is unreserved, your lordship. Now, my lord, even obviously he can apply for that post. No problems.
Yes,
but if he is what I am trying to convey.
Mr. Nohali said that it's post based.
Post based.
It's not merit based.
Lordship.
So that is, but then it's anyway. It sounds very illogical.
It is post based, my lord. And as I said, my lord, why there has to be 2 interviews? Because the composition changes. Composition of the selection committee, because when it comes to, my lord, the reserve category,
there has to be a person's reserve category sitting in the panel. Right? That's what you're saying.
Yes. And then what I said, because there is a now, my lord, common online platform at the behest of the UGC.
Can you show any other instance where this same practice has been, has been implemented with regard to selection?
In the university?
Yes.
In the university? That's why I'll have to find out, my lord.
You find out.
I can find out.
You see, that's something which defies like the general,
Lordship. Now, my lord, okay, my lord, for your lordship understanding, perhaps.
Yes, for my. We are learning something every day. That's what.
So far, this case is concerned.
This trouble is caught right.
I understand. I understand.
That that a person comes out in 2 lists. His name appears in 2 lists, unreserved list and OBC list also. That is what trouble is.
Yes, my lord, I'll try. But so far, this case is concerned in the facts and situations. Now, so far the merit list is concerned, my lord. General category also respondent number 6 he applied. Now he appeared at serial number, merit list 7. Now person appointed, my lord, respondent number 7 at 1. Read petitioner appeared at serial number 5. Now in the OBC category, my lord, 6 at 1. So that conflict is not there in this case. But even for your lordship understanding, my lord, even if there are other cases, my lord, then I can find out.
No, just the whole mechanism behind have the logic. Why you having to? Why can't it be like one general application?
I understand, my lord.
If you see
then based on the marks,
India says that UGC has given one application, one single application. Then in this case, it makes a exception that you put 2 applications, one OBC.
But that is, I think, if they had made UGC party, they would have their guidelines.
UGC is a party. Where's MS Long State?
I don't know. This is the UGC guidelines. Now UGC guidelines, where is that?
UGC is a party based in Shillong.
No, she is based on Shillong. She is lottering around.
I'll just reading 8, guideline 8, no?
Last time also, my lord has said that she will appear, and she has taken instruction. She said also, if the court permits, I will file an affidavit, but she is not there, my lord. And the interpretation of the UGC regulation, what my lord senior is interpreting, my lord, they will be the correct authority to interpret.
My lord, just again read the guidelines. These are being issued from time to time. Procedure to be followed in the matter of reservation for teaching as well as non-teaching staff, without prejudice to any procedure prescribed.
Where are you reading from?
Point 8, my lord.
No, it's not been. Where's point?
Point 8. Procedure to be followed in the matter of reservation for teaching as well as non-teaching staff. Now, without prejudice to any procedure prescribed under various instructions from the central government from time to time, the following guidelines are to be followed.
Okay.
SC, ST candidates should be interviewed separately. And we have incorporated this in our ordinance.
Have you put it in the affidavit?
These are not the issue. That's what the problem with the
issue. There's no pleading.
That specific pleading is not there, my lord. Why should I shy away? What is there? I have to polish that only.
I could have, my lord,
whatever weapon you have to fight
with that, my lord.
I could have come up with a better answer, your lordship. I could have looked into the records. Now, what your submission I am making only on the basis of the
earlier occasion, my lord, senior said that he has gone through the record.
Guideline. Yes.
Now, my lord, it's clear. So, based on this, my lord, as your lordship know, under UGC, my lord, they are the, my lord, sponsoring authority, my lord. I cannot go against them. We have incorporated this in our ordinance. There is, what is the ordinance? OE3, my lord. Ordinance OE3. Ordinance OE3, my lord. This. No, not this. That there is this thing OE3. This one is constitution. Sweet. This one. My lord, OE3, if I can take my lord, OE3.
1 second. So these instructions are statutory in nature.
Guidelines, but then we have incorporated. We have to, my lord. Guidelines have to be followed. These are the guidelines.
Now, what you see was written here at page 2 of this guideline given me.
Page 2.
From this UGC, this one, guidance for strict implementation.
Page 2.
On page 2, that clause 3.
Yes.
The instruction issued government as statutory in nature.
The instruction issued by the statutory in nature as per the judgment of the Honorable Supreme Court. Yes, ma'am. It is statutory. And that is the reason we have incorporated. That's what I will rely.
Yes, we get it. Yes.
My lord, we are, my lord, relying on OE3. Then OE3, if your lordships comes to, my lord, clause Roman 4.
But OE3.
Roman 4.
Yes.
6, serial number 6.
Yes.
I just read it. When selection committee meetings are convened for the post of different categories together, candidate for the reserve category post shall be interviewed separately.
It just echoes what
Exactly, my lord. That's why I say that it is different, my lord. It is post-based. It's unlike, my lord, the UPSC, MPSC, other things, my lord. It is something unique, your lordship. And that is very clear and obvious from the Act of 2019. It has to be. So, my lord, what we have done as per the UGC guideline, as per the law, my lord. So, my humble submission, my lord, there is nothing, my lord, which call for an interference from this honorable court. And your lordship, 2019, even in 2019, that decision, my lord, the state university and other thing, my lord, they have not interfered with any selection. Selection they made, they have saved it.
Yes.
My lord. So, that's my humble submission, your lordship. Anything more? Okay.
Yes. Who's next? At 2 o'clock, Mr. Arisa? At 2 minutes. Yes.
And my lord, if lordship want to see that proceedings, my lord, these records, I can place it.
If any urgent hearings, I can see the worried look in Mr. Filai's face.
No, Your Lordship. There is some item with Mr. Day, Lordship. We can have 34 and 34.
He's looking worried. He does not stay after long.
We can file it.
So let it come up next week, my lord. This 34. And even 26 also, let it come after 2 weeks, my lord.
26 is MRB matter, Your Lordship.
Let it come after 2 weeks, my lord.
Part heard. 34, Your Lordship.
34 next week, my lord. And 26 after 2 weeks, my lord.
Where is he?
Lordship, 35, my lord. It's not, I'm not what to argue, but I'm taking time.
Yes.
35.
Yes, adjourn for 2 weeks. Yes.
Lordship. Must be Lordship.
My lord, there is item under 36. 36 judgment, I mean, hearing has been concluded. Now, lordship has asked us to file our compilation. 36. Hearing has been concluded.
Have posted tomorrow.
For filing of this thing.
My lord, item 30 and PIO, my lord.
Yes, item 30.
This matter, my lord, is a very short matter where the lawyer.
Then at 2 o'clock.
Your lordship may have it after a week or so, my lord.
Otherwise, no issues. You're ready at 2 o'clock after the other matters.
Advocate General is not
Okay, after 1 week. Yes.
Item number 31.
You have some urgency?
No urgency.
Then we'll do it.
Next week or after a week?
After 2 weeks, my lord.
What 31? So this is regarding that
Land.
The land, my lords.
we have because next week is hardly any.
Yes.
Till after the 7th. Then.
Lordship.
After 7th.
Obliged.
We'll continue at 2:15.
Yes, for my landed friend, only one small thing.
Yes.
One small thing. In course of submission, my landed friend also said that in botany department it was rejected. That respondent number 6 applied in botany department. So, my lord, that, so my lord, no, my lord, that is not in the part of the pleadings, my lord. So I'm unable to answer that. Number one. Number two, my lord, regarding JNU and all, my lord, only thing I can say that is also not a part of the pleadings. What he has said that JNU, that was in respect of assistant professor. The qualification is altogether different. And I have been told, my lord, the matter is pending now. JNU is not a party to substantiate that. And my lord, the matter is now pending before the High Court Delhi somewhere, my lord. And my lord, regarding pleadings, I have included a decision here. One is on pleading, my lord, what are the consequences of not pleading in my compilation. Another thing, my lord, I am also saying it is not maintainable vis-a-vis, my lord, respondent number 7 also. Because he having participated, my lord, conscious about it, could not have. That decision also I have included.
Please note, my senior has covered almost all the points. I will try to brief my submissions, my lord. Before I travel there, since senior has pointed out, the matter arising from the university JNU is still pending before the Delhi High Court. This is for the assistant professor. It has nothing to do with the present writ petition.
Yes.
Now, when we come to the present here, my lord, the maintainability of the writ petition.
Yes.
Now, this, my lord, my right to participate under Article 16(1), right to equality, my lord, is available to all the. Is a right to equality under Article 16(1) is open to everyone, including me. However, my lord, right to contest or participate under Article 16(4), the reservation, my lord, petitioner is excluded because the reservation is a constitutional concession given to a special group of people. Therefore, challenging my appointment by the writ petitioner, he is entering, your lordship, he is inviting this honour court to enter into the constitutionally prohibited territory. He has no locus at all, my lord. To substantiate that one, my lord, I will cite one judgment to the point. 2013, I've submitted the list of book in the morning. 2013, volume 4, ACC. Well, page number 465. Relevant para, my lord, 1718, 47, 48. Here, my lord, the general category candidate challenged the caste certificate of the ST candidates appointment. Method traveled to Supreme Court and Supreme Court held this. May come to para 17.
Yes.
17, 18. Para 17, 18 till 19 May. This
is Ayub Khan.
Yes.
17?
Yes.
In view of the above?
Yes. In view of the above, the law on the said point can be summarized to the effect that the person who raises a grievance must show how he has suffered legal injury. Generally, a stranger having no right whatsoever to any post of property cannot be permitted to intervene in the affairs of others. Local standard of respondent number 5. As respondent number 5 does not belong to the scheduled tribes category, to carve adopted by him of serving the cause of scheduled tribes candidates who might have been deprived of their legitimate right to be considered for the post must be considered by this court in order to determine whether respondent number 5 is in fact in a legitimate position to lay any claim before any forum whatsoever. In this court instance's case, Sri Sansasan's ex-president was the claimant. Thus, at the most, he could lead evidence as a witness. He could not claim the status of a personal litigant. The complainant cannot be the party to lease. A legal right is an averment of entitlement arising out of law. In fact, it is a benefit suffered upon person by a rule of law. Thus, a person who suffers from legal injury can only be challenged the act or omission. There may be some harm or loss that may not be wrongful in the eye of law, because it may not result in injury to a legal right or legally protected interest of the complainant. But juridically, harm of this description is called such and such. The complainant has to establish that he has been deprived of or denied of a legal right, and he has sustained injury to any legally protected interest. In case he has no legal leg for a justifiable claim to hang on, he cannot be heard as a party in the lease. A fanciful or sentimental grievance may not be sufficient to confer locus standi to sue upon the individual. There must be an injuria or a legal grievance which can be appreciated and not by such and such. My lord, number 20. Similar view has been taken, reiterated by this court in such, wherein it was held that the applicant before the High Court cannot challenge the appointment of a person as she was not in no way aggrieved, for she herself could not have been cited by adopting their method. So my humble submission, my lord, he is not applicant for OPC. So my submission of the two application The question, my lord, whether my submission of application, second application for general post, whether it affects his right. That is the question. My humble submission, my lord, mere submission of application, second application for unreserved post. This is absolutely, I derive that right from Article 16.1. It doesn't affect his right. It doesn't impact his right. Therefore, my lord, the writ petition itself is not maintainable, my lord.
Yes.
Now, the only reply given by him that why it is maintainable, I have taken this in my affidavit, and his my lord, the writ petitioner has given a reply in my counter for maintainability of the writ petition, my lord. My lord, can you see, come to para 4 of his rejoinder. This is the only reply he has given. Because I challenged the maintainability in my counter affidavit, and this is his reply. Paragraph 4, my lord. Paragraph 4 of the rejoinder affidavit filed by the petitioner in response to the response number 6.
Yes.
This is response to my maintainability, my lord. In the, my lord, the page number 3, it says, it is further stated that response number 6 has participated and screened by the screening committee under both reserved and unreserved category in the selection process. As such, petitioner having been participated under the open category can challenge the illegal appointment response number 6, and further he is necessary party in this case. This is only reply. My participation, my lord, in the selection process, but how he can challenge my appointment process? He cannot, my lord. He has no locus to. Now, second point, my lord, I'll come with regard to first maintainability is my submission. Writ petition should be dismissed with a heavy cost. Earlier writ petition also lordship has imposed cost. My lord, here I would understand without impleting me if the question, the other process, we understand. But so long as he impleted me as a party, writ petition itself is at all, not at all. Second issue, my lord, he challenged the screening committee selection process, my lord. That is his contention. I would place that.
You done the judgment, right?
Yes, my lord.
Yes.
My humble submission is that, my lord, in the first writ petition also, he did not challenge the formation of the selection committee or screening committee.
Yes.
He did not challenge the, my lord, the bona fide of the application filed by all the parties, including me.
Yes.
In the first round litigation. And my lord, can you see the prayer? There is no prayer for setting aside the entire selection process. My lord, can you take the pen to see his prayer? Prayer and petition. My lord, he only prayed for setting aside my appointment and the response number 7 appointment. There is nothing, my lord, seeking for vitiating the selection process.
Oh, I was on the impression that he had vitiated the entire selection process.
Nothing. And there is no whisper in the entire pleadings.
Oh, so he has not questioned selection process.
My lord. Therefore, my submission regarding this judgment, my lord, I may place two judgments. My lord, 2011.
But Mr. D was arguing along those lines that the whole selection process.
No pleading at all, no foundation. But 2011, volume 12, page 695.
Volume?
My lord. Volume 12, my lord. 2011, volume 12.
Volume 12.
Volume 12, my lord.
Yes.
ACC, page number 695, relevant para 12 and 16.
Okay.
There is no pleading for conducting second interview or two interview, nothing is such. My lord, you can take a pen with me to para 12. Para 12. The pleadings and particulars are necessary to enable the court to decide the rights of the parties in the trial. Therefore, the pleadings are more of help to the court in narrowing the controversy involved and inform the parties concerned with the question in issue, so that the parties may adduce appropriate evidence on the said issue. It is settled legal proposition that is a rule relief. As a rule relief, not founded on the pleadings cannot be granted. A decision of a case cannot be based on grounds outside the pleadings of the parties. The pleadings and issues are to ascertain the real dispute between the parties, to narrow the area of conflict, and to see just whether the two sides differ. My lord, number 16, my lord. In such, my lord, this court held that unless factual foundation has been laid in the pleadings, no argument is permissible to be raised on that particular point. So it is very, very clear. And my lord, for my lord's satisfaction, I place that 2004, volume 2. Well, 2004, volume 2, page number 76.
Page 76.
Page 76, relevant para, my lord, 25 and 26. 25 and 26. Relevant.
Yes.
May I reply? Effect of absence of reservation as an issue. Order of the reservation was admitted not in issue before the High Court. In the aforementioned fact situation, we are of the opinion that the High Court, in absence of any specific challenge to the reservation policy adopted by the bank, could not have gone into the said question. It's true that the High Court is entitled to take into consideration the subsequent events, but the same can only be a relevant factor for the purpose of molding the reliefs. But while molding such reliefs, the High Court could not consider grant of relief, wherefore no factual foundation existed or was laid in the pleadings of the parties. It has been accepted by the bar that no factual foundation was laid down in the petition before the High Court as to whether the bank complied with the requirement of Clause 7.7 of the procedure providing for exchange of reservation between SC, ST, and vice versa. The question as to whether any eligible sexual caste candidate was available for promotion to the post of officer or not is essentially a question of fact. It is thus not open to the High Court to advert to the said question. So with the pleading about formation of a composition of the screening committee, selection committee, holding interviews, these are not part of the pleadings. It is not tenable in law. Now with regard to my lord, I come to my lord, he said that I don't have the experience, but I completely adopted the argument advanced by my own senior standing counsel for the NEHU. I just point out that clause, it doesn't require teaching experience. And I'll show only a few annexures in my affidavit, my lord. My lord, we kindly come to page number 27 of the counter affidavit.
Yes.
27, my lord. Here also, my lord, regarding the experience. My lord, this is the issue by the competent authority. It says, my lord, the issue regarding the counting of the period of active service spent on pursuing PhD was considered by the UGC as such. The clarification of UGC is as follows. The period of active service spent on pursuing research degree, that is for acquiring PhD degree, simultaneously, without taking any kind of leave, may be counted as a teaching experience for the purpose of direct recruitment or promotion to the post of associate or professor in above. Even for the teaching, my lord, this concession is given by the UGC. In my case, my lord, category B, my lord, it is not required teaching experience. And my experience is 10 years. It is more than 10 years. I make a specific amendment in para 12 of my counter affidavit, my lord, who is lordship. Para 12 may be take note of, my lord.
From your affidavit.
My affidavit. I have more than 10 years experience. And writ petitioner has no right to challenge my eligibility. But another point, my lord. He says, my lord, the bioinformatic, my lord, it is not part of the zoology. That was already addressed in the first round of litigation. I would invite my lord to see lordship order that petition, my lord. My lord, we come to the writ petition filed by my colleague, page number 62. Page number 62 of the writ petition. My lord has recorded the submission of all the councils in that writ petition.
62 writ petition?
62 of the writ petition.
Yes.
62 of the writ petition.
Yes.
62, well, part of 156, lordship has recorded and even reproduced the, my lord, the qualification, my lord. And the next page, para 62, 63, para 8 at the bottom, my lord, lordship finding is still. A perusal of the criteria as above shows that an applicant is eligible to apply for the post of professor if one is an eminent scholar having a PhD degree in the concerned allied relevant discipline. The School of Life Sciences having included other departments such as biochemistry, biotechnology, bioinformatics, and botany departments from zoology. It would follow, therefore, that candidates possessing PhD in these departments can also be considered for the same post. He did not challenge. I come from the bioinformatics department. He could have challenged it, madam. He did not challenge. For the principle of estoppel, madam, whoever comes into play, he cannot raise that issue anymore, madam. But lastly, I would show my application, and his application, I would raise my submission, my lord. In the writ petition, my lord, in my counter affidavit, my lord, with regard to my, before I come to the application, my lord, I would come to my qualifications and competency.
Reading from?
Yes, my counter affidavit, lordship, can you see?
Yes.
My lord, my experience certificate also, my lord, issued by the authority, page number 24, by the Provice Chancellor, my activities in the university, page number 24 of the counter, annexure 3. My lord, he has enormous experience in this field. And he is recognized by the university. I don't take note of it. I will not read it. And Reed Petitioner himself recognized my expertise in the subject. Therefore, he invited my party to deliver an address, my lord, to the student, my lord. Page number, my lord, 85, my lord, 86 and 87. My lord, 87 and 88, the last page. He himself invited respondent number 6 to take part in his department. His own letter authored by the Petitioner himself. Page number 87 may I take first, my lord. Annex 6. My lord, address to the respondent number 6. Now, this is to inform you that an online selection committee meeting following COVID and such have been convened on such in the Biodiversity Hall. Department of Zoology Nehu Sunset for selection of GRFs under the above mentioned project. In this regard, you are invited as special invitee for the selection of GRFs for the selection of GRFs to the now the zoology. If bioinformatics, my lord, doesn't have any experience in the field, why did Petitioner himself invited me? And the last page is page number 88.
Okay.
My lord, the last annex, page 88, that was authored by the Petitioner himself to the respondent number 6. My lord, subject refresher course Zoology 2022. It says, Department of Zoology in Sunset Nehu will be organizing a refresher course in zoology on the theme Recent Advance in Zoology from 21st Sunset 2022. The program will be attended by college and university teachers belonging to various disciplines and the life sciences. The focus of refresher course will be on the application of basic sciences and biotechnology on society. Considering your expertise in the subject as to provide the participant latest updates in your areas of interest, may I invite you as a resource person. In this connection, I would like to request you to kindly interact with the participants of the program online mode through My lord, topic is fostering bioinformatics education through the skill development of educators. So he himself recognized that bioinformatics is part of the zoology. And therefore, he cannot challenge before this court that I don't have a requisite qualification, and he cannot challenge it because of the locus. My lord. I would come to my application, show the application, and rest my submission. My lord. My applications, my lord, page number 59 of my counter affidavit. 59.
Yes.
59. Annexure 4. This application, my lord, the category, my lord. This is under the system, my lord, available in the in the portal. Therefore, category. My lord. He mentioned OBC. He mentioned, my lord, he cannot apply the system. He cannot apply for port. He cannot mention port. Because the system asks him which category you are coming. So he mentioned that one. And this is under, my lord, member submission. This application is under Article 16.4, the reservation. And now the next application, second application is page number 76. Category unreserved, my lord. This second application, my submission is, my lord. Even without this, my right to be considered if I outshine general candidates to debate. And this application is considered, my lord, is acceptable under article, my lord.
That's why I was asking Mr. Sen whether there any instances before where it happened to applications being put under two categories for one post. That's the only thing that was in the amendment code. If the pleadings are made to that effect, then
and nothing is made regarding to that effect also. And his own application may show and address my submission. Page number 76. My lord, this
page number
47 of the writ petition. The application filed by the petitioner himself. But he also mentioned category unreserved. This is under Article 16.1.
No, it's unreserved.
Unreserved. It's unreserved. It's open door.
Unreserved candidate yes. Be applied twice.
It's open door, my lord. Open door.
Taking your chances. That means in the case you might qualify OBC, perhaps you qualify for reserve. That's the only thing. That's the only conclusion that can be drawn. Right. That you just like you know.
Right. Therefore, my humble submission is that
my target you fire 2 bullets.
Yes. Like therefore, my second application did not violate any legal rights of the petitioner.
But if it was one post, one like is not on merit, then maybe there's some credibility that you apply for both in case you don't do so well in OBC, you do unreserved.
Exactly. With abundant caution only.
Well, the system accepted also.
Yes, system accepted.
There must be something behind.
My lord is right. The system accepted. System command that one. Therefore, he responded with abundant caution only. That doesn't invade the right of the petitioner. My humble submission in my petition is devoid of it should be dismissed on the ground maintainability. Even on merits, my lord. There is no case made out by the petitioner. Give it up.
But firstly, I'll take your lordships to the advertisement. Let's start from the beginning, my lord. Your lordships may kindly have the writ petition. The advertisement, your lordships will find at page 33. Page 33, my lord. Now, if your lordship sees, the advertisement is dated 16th of March 2022. And my lord, the first word used in the advertisement is online application.
Yes.
Online application. I invited for internationals for filling up the post of professor in various departments in Northeast Hill University in both the campuses at Shillong and Tura, Meghalaya. For details, please visit University official website so and so. The last date of receipt of application is 18/4/2022. On the next page, my lord, page 34, your lordships will find the post in various departments. In the second column, my lord, on the top it says department, my lord.
Yes.
And on the last column, it speaks about specialization.
Yes.
Last column, my lord. Now, page 35, your lordships will find the relevant post. Page 35, serial number 13.
Yes.
So 12, 13 and 14, my lord, of in the School of Life Sciences. Again on top, my lord, this is the department. So zoology is the department, and specialization has been provided in the last column, my lord, which I will take, which I will come back to this, my lord. I'll come back to this. Firstly, I'll just...
Maintainability, you're not saying anything.
No, I will say, my lord. I will say, I'll just clarify the doubts, my lord, and then I'll come to the maintainability. Now, your lordships may kindly have page 38. How to apply. It says, my lord, how to apply. Applicants can visit NEHU website so and so for advertisement details. And for applying online, please visit recruitment.nehu.ac.in. This is important, my lord. Now, what happens is, my lord, we have to my lord, go to the website and apply online. We have to fill the form. There's a form. And after filling the form, then in the other terms of conditions, your lordships may kindly see. Number one, the hard copy form generated online, which duly signed on every pages, should be submitted along with the uploaded necessary supporting documents. The complete hard copy of application, either so and so. Number two, my lord, is the eligibility, my lord. The eligibility criteria of the candidates and other terms and conditions shall be as per the UGC regulations 2018. Now, I will not trouble your lordships because Mr. Sen has already pointed out. Now, this is the advertisement, my lord. Now, your lordships, on the how to apply, I had just read out the website, my lord, recruitment.nehu.ac.in. Now, what happens, my lord, if I go to the website, is this, my lord. I cannot demonstrate online, my lord. So, what I've done is, my lord, I've just printed out the how to apply, my lord. May I just hand over, your lordship?
Thanks.
Now these are from the website, Milord. It says, Milord, frequently asked questions. Number one, how to register. Answer, go to the website recruitment.nehu.ac.in and click for teaching. Important is, Milord, I'm teaching in the Department of Biochemistry, Northeastern Hill University as assistant professor. And the courses and subject taught by me, Milord, the very first one, Milord, biomolecules. This is very important, Milord. I'm teaching biomolecules. Middle of the page, Milord, 4.1, research papers.
Yes.
Almost all my research papers, Milord, which I'll point out, Milord, number 1, number 2, number 3, number 4, number 5, number 6, number 8, and on, Milord. These papers are all in relation to biomolecules, molecular biology, Milord. Now, page 11 onwards, Milord, page 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, I have, Milord, 90 publication of papers, Milord. Now 4.2 at page 21, your lordships will see the books which I've edited and which I have published, Milord.
Okay.
Page 22, your lordships will see at 4.5, projects I have handled, Milord. So if your lordships directly comes to page 27, This will indicate, my lord, and in the second row, my lord, total research publications 90, books 2, book chapters 9, total citations 1800 plus, involve the inviting of applications developed by the respective university. That is the application which I have pointed out to your lordships. Based on the assessment criteria, methodology guidelines set out in regulations as per Appendix 2, Table 1 and 2, and reprints all the significant publications and candidates. Although already pointed out by the learned senior appearing for the university, Roman 7, my lord. Under these regulations of 2018, my lord, the university has to set up a cell which is called the Internal Quality Assurance Cell, IQAC, shall be established in all universities, my lord. So in 2018, my lord, this became mandatory. Now I'll take your lordships to the additional affidavit filed by the petitioner. Your lordships kindly have the OE4 affidavit filed by the petitioner, latest affidavit.
Last affidavit.
Yes.
Screening committee.
Yes, screening committee. I'll just point out a few things. Your lordships has page 8. Page 8, my lord. Now, what is relevant is, my lord, the last line, my lord.
Similarly.
Similarly, my lord. Submissions were made prior to this, my lord. But what is important is similarly,
that is
a committee
highlighted by.
Yes, my lord. Shall be constituted by the head of department, or the senior most professor, or dean of the school, or the vice chancellor. In this case, vice chancellor has done it, as the case may be, for scrutinizing the applications. This committee shall comprise of not less than 3 teachers, and shall include all professors in the department, and at least 1 professor from another department in the school, or other school professors who are so and so, my lord. Your lordships kindly have next page, page 10, my lord. Page 10, the second Roman 7, my lord, is also important, which is missed out by the university, my lord. So the findings of the recommendations of the screening committee is not final. As per Roman 7, my lord, small Roman 7, it says applications along with recommendations of the screening committee shall be forwarded by the chairman to the vice chancellor for approval. The vice chancellor may refer the matter to the committee to review its decision for reasons to be recorded. So, my lord, even otherwise, the vice chancellor has the power to review and, my lord, remand it back. Now, my lord, what we have read, my lord, similarly a committee shall, which we have read earlier, constituted by the head of the department. Now this is for general. Kindly have serial number 8, my lord, at page 10. Reserve post, my lord.
Yeah.
Reserve post is totally separate. So there's a reason, my lord, that reserve posts are treated different footing, my lord. Reserve post, it reads, my lord, in case of reserve post, the same procedure may be followed, but it is a separate provision. Now coming to page 11, my lord. Regarding the constitution, this has been done by the vice chancellor, my lord. Now, the requirements for, my lord, shall include all professors. The dean of School of Life Sciences, my lord, is a professor of zoology, so therefore he has to be included, my lord. And, my lord, being senior most in the department and also in the university.
After he chaired it.
Yes, my lord. And, my lord, your lordships will see at serial number 4, Professor A.S. Dikshit. Now he is also a professor of zoology, my lord. So as per the clause, my lord, shall include all, has to be included. Now at number 7, again Professor A.S. Dikshit, my lord, by virtue of that, my lord, yes, my lord, of UGC, my lord. So, my lord, there's no defect as far as the constitution is concerned, my lord. Now the other thing, my lord, my learned friends made a submission that the screening committee and the selection committee is the same thing. It's not the same thing, my lord. Screening committee is covered under OE4, which we read, my lord, and selection committee is under OE3, which was pointed out earlier, my lord. I'll just hand over a compilation, my lord. Small compilation of.
What is this?
Now, my lord, regarding the allied and relevant subjects, my lord. This is, my lord, the Board of Studies This is for, for fixation of syllabus and all that. If your lordships kindly have at table A at page 4. So as per academics, also your lordships at serial number 12, your lordships will see the allied and cognate subjects for biochemistry is botany, zoology, biotechnology, and bioinformatics. Number 14, my lord, for botany, zoology, biochemistry, biotechnology, and bioinformatics. 15, my lord, zoology, botany, biochemistry, biotechnology, and bioinformatics. Even in academics also, my lord, these are all, my lord, allied subjects. Now, if your lordships kindly have page 8, this is a syllabus for the postgraduate. This is the NEP 2020 PG syllabus. First semester, second semester, third semester. Your lordships kindly have the subject at 502, the third one, animal physiology. This involves molecular biology. 504, animal diversity. This also involves my specialization. Subject number 506, biological chemistry and molecular biology. This is also my specialization. Third semester, serial number 601, fish biology, my subject. Biosystematics and evolution, my subject. 605, entomology and insect physiology. This is my subject. So this is the syllabus. Now the last page, page 27, this is, my lord, a list prepared by the Stanford University, my lord. Page 27, my lord.
Yes.
It's a certificate, my lord.
Okay.
Tripathi Timber, my lord, ranked so and so. So I'm amongst the top 2% scientists in the world, my lord. Now, what is important by this certificate, my lord? You may kindly see what is the main field: biomedical research, subfield biochemistry and molecular biology. My specialization, my lord. Now, my lord, I'll take your lordships to the ground of maintainability, my lord. Straight away, my lord, I'll just...
It's okay. Anything to add to the submission, so on maintainability, or you have another?
Mine is totally separate. Okay. He's on locus.
Yes.
Before that, I'll just point out to your lordships a few dates. The advertisement is, your lordship, advertisement is dated 16th of March 2022. Last date of submission is 18th of April 2022, my lord. The committee was formed by the Vice Chancellor on 6th of December 2022. 6th of December 2022. Now, from 6th of December 2022, the petitioner did not approach this Honorable Court challenging the constitution of the committee, my lord, screening committee. It is only in July 2023. It is only in July 2023 that the petitioner approached this Honorable Court, my lord, by filing a writ petition, my lord. 24th of July 2023 was the filing date, my lord, and the judgment was delivered by this Honorable Court, my lord, on 8th of August 2023. In that writ petition, my lord, from December to July, no challenge. There was ample time, my lord, no challenge to the constitution of the committee. Now, your lordships have delivered the judgment, and on the point of, as pointed out by Learned Senior, regarding the School of Life Sciences and Allied Subjects, so I will not go into that. But the point is, from December 2022 till July 2023, no challenge. Writ petition was filed, again, my lord, no challenge. No challenge to the constitution of the committee, my lord. Now I'll take your lordships to the judgments. One more point, my lord. In this present writ petition, second writ petition, here also, my lord, no pleadings regarding the challenge or no prayer regarding challenge of the committee. May I just hand over the judgment, my lord? This is, my lord, in the case of Dr. G. Sarana, reported in 1976, volume 3, Supreme Court cases, page number 585. Your lordships may kindly have internal page 587. These are the facts. Para 2, my lord.
Yes.
Para 2, the facts giving rise to this appeal. Towards the end of the year 1973, the university put up an advertisement inviting applications from candidates possessing the following qualifications to fill up the vacant post of Professor of Anthropology. Number 3, the appellant and respondent number 8 were the only two candidates who applied for the post in response to the advertisement. Their respective qualifications are set out as hereunder. Number 4. Now, your lordships kindly have para 5. Before para 5, that last paragraph, Executive Council of the University, after interviewing the aforesaid two candidates, and the selection committee resolved to recommend the respondent number 8 herein for appointment to the aforesaid post of professor. Number 5, on coming to know of the recommendation, the appellant filed the aforesaid petition under Article 226 of the Constitution, challenging the recommendation mainly on the ground that two of the aforesaid 3 experts were biased against him in favor of the respondent number 8. Now findings, my lord, at page 591, para 15. This is the finding of the court, my lord. It says, my lord, we do not, however, consider it necessary in the present case to go into the question of reasonableness of bias or real likelihood of bias, as despite the fact that the appellant knew all the relevant facts, he did not, before appearing for the interview or at the time of the interview, raise even his little finger against the constitution of the selection committee. He seems to have voluntarily appeared before the committee and taken a chance of having a favorable recommendation from it. Having done so, it is not now open to him to turn around and question the constitution of the committee. This view gains strength from a decision of this court in Manaklal's case, where in more or less similar circumstances, it was held that the failure of the appellant to take the identical plea at the earlier stage of the proceedings created an effective bar of waiver against him. Following observations, Bullet. So this is one judgment, Bullet. Second judgment also, Bullet, relies on this Dr. Sarana judgment, which is, Bullet, 2016 judgment, Bullet. This is the case of Madras Institute of Development Studies and another, reported, Millard, in 2016, Volume 1, Supreme Court Cases, page number 454, Millard. So I have marked the paragraphs, Millard. The facts are at paragraph 2 to 4, and the findings are at paragraph 14 to 18. I will not trouble your lordships because at paragraph 15, this Dr. Sarana has been cited, Millard. Third judgment, Millard, which is the last judgment, this is on judicial review, Millard, in cases of appointment, Millard. This is, Millard, Muhammad Mustafa, Millard, reported in 2022, Volume 1, Supreme Court Cases, page 294. I'll just hand over a copy, Millard. I've marked the relevant paragraphs. So, Millard, my humble submission is, Millard, not only that this writ petition is not maintainable, in view of the fact that the petitioner had taken part in the entire exercise process without challenge, my lord. Without challenge. Even on facts, my lord, even on merits, my lord, the petitioner has no case. So, my lord, the writ petition will be dismissed, my lord.
Thank you, yes. My lord, certain judgments my friends has placed. I would like to go through, my lord, and address this court, my lord. Only, my lord, 10 minutes I will take, my lord.
My lord,
Not now, my lord.
I missed out one thing. I'll just...
let him finish.
My lord, yesterday, two judgments were relied upon by my learned friend, my lord, for the petitioner. One is, my lord, that High Court of Bombay judgment, my lord. My lord, the facts of that case is totally different. What had happened in that case is, my lord, the committee was constituted But when the interview took place, my lord, somebody else sat. So that is totally, my lord, on different set of facts. And even on regarding the Tripura case, my lord, Tripura case also, my lord, it is changing the rules after the game has started. So, my lord, those judgments are not applicable, my lord. Deeply.
Yes. I will reply, my lord. Just, my lord, may kindly give me 1 day time, my lord. At least I will go through all these judgments and I will address this honorable court. Because one fact that the Standing Council of Nehu has not addressed, my lord, that respondent number 6, whether he is qualified or not. That I will address, my lord. And second, my lord, I would like to go through these judgments.
But that's been addressed by Mr. Changrai, so
that is what, my lord. The point which I have, the point which I have highlighted, the point which I have highlighted, my lord, has not been addressed, my lord. I will just revise those points, my lord, and then, my lord, after going through these judgments, my lord, I can argue this, my lord. I can place.
And again, they'll have rejoinder arguments.
No, I didn't
become
so,
a
my friends has argued in land, my lord, with the judgments. So I would like to go through the judgment. I would like to just go through the judgments, my lord. Moreover, my lord, Mr. San, he has given compilations also and certain.
No, I would like also just not so long, but just notes on submissions, bullet points.
I will just, my lord, request let it come up on 27, my lord. We can finish it off, my lord. I will take only half an hour on 27th, my lord.
Tomorrow?
No, oh, sorry, not tomorrow, my lord. Oh, I was looking this. Let it be on first, my lord. On first, I will finish it off only half an hour, my lord. I will not go beyond half an hour, my lord. I just need to take my instruction of my clients and so on.
Mr. So list the matter on 1st April for joinder arguments.
Yes.
By the General Counsel for the petitioner.
My lord, only thing, my lord, I'm just reminding your lordship regarding, my lord, cases cited by him. My lord, in my compilation, my lord, I have already mentioned, my lord, how these are not relevant. This is there, all this in compilation.
We will examine
the Tripura case and other case, my lord, this has no application. Why this has no application, I have clearly said.
I also, my notes also scattered now.
Yes.
26. Yes.
Hello, brother.